Yes.
My lord, I am ready and willing to settle the matter, my lord, in case the amount.
Yes. The petitioner and the second respondent pray for some more time.
Lord, may I submit one thing, Lord?
Yes, yes.
Lord, I request, Lord, that the parties be, Lord, directed to appear before the mediation center at High Court, Chandigarh, Lord, because both the parties are resident of Chandigarh, Mohali, Lord,
No, but
in the
the
local
difficulty
area.
is that he is in jail in some other case. He cannot appear before the mediator.
Lord, on his behalf, somebody from his family or any other person, if
No,
because,
but
because the amount has, Lord.
Settlement has to be signed by the party concerned, not by the
Yes,
council. That is the
Lord, it has.
difficulty.
It has. My lord can record my undertaking, Lord.
Or you withdraw the FIR. If you say that you withdraw the FIR and you file a 142 application, both of you, in this bail will quash the FIR.
We are ready for that.
You work out that modality or methodology, whatever, will give you 4 weeks time. In the meanwhile, you sit out.
As my lord.
Calculate.
And the second respondent prays for some more time.
Prays for some more time to work out the settlement and inform this court. First of parties, inform this court. First of post the matter on 23rd March. Interim bill to continue.
Lord, in the meantime, Lord, half of the amount, the registry may be directed to release half of the amount, Lord, because the complainant, they are very, Lord, downtrodden. They have taken loan, Lord. Now her sister has gone abroad, Lord, after taking loan. They have to, Lord, repay the
No, but
installments.
if after withdrawing the amount, you back out from the.
No, Lord, my lordship may record my undertaking, Lord.
No.
Lord may record my undertaking, Lord. I'll be bound to give statement whenever it is required, Lord.
No. Let it be.
Lord,
You will get it in one go. If you wish, we can fix some earlier date.
As my lord may fix it for an earlier date.
9th March. 9th March.
My lord, is the 9th between 27th February to 15th March. I'm traveling to the Madhya Pradesh.
27th for.
There's the marriage of my Banji. So for that reason,
his marriage 20 days.
I have to arrange everything, my lord.
That is to be prior to 9th, Lord. Prior to 9th, 7th. Also.
Then 27th February.
Grateful.
27th February.
Lord.
Yes.
Grateful, man.
27th you are here?
27th.
He is there.
Please.
It's only for settlement.
Yes.
Yes. I will join virtually.
Yes, better.
Grateful, man.
Lord, grateful.
Item 4, my lords, this is a case where I was granted anticipatory bail. I appear before the learned trial court in terms of.
No, you did not deposit 6,05,000. That is the allegation.
No, my lords.
Yes.
There is no such allegation, my lords. This is a.
Read the impugned order.
My lords, that is item 5, my lords. This is 4, my lords. Item 4.
4. Yes.
I'm sorry, my lords.
Yes.
My lords, this is a case where I was granted anticipatory bail by the Honorable.
40,90,000.
Please, my lords. My lords, this is the allegation.
Yes.
My lords,
deposit the amount.
My lords,
shortage of 40,90,000.
Because this amount, it is logically absurd that I could have taken out from the bank, my lords. There are 2 keys to the vault, admittedly, that is the prosecution case. The another key is with the branch manager, without which I can't even open the vault, my lords. I was granted anticipatory bail. I have participated in the trial, my lords. With the investigation as well. There is no record that I have not cooperated with the investigation today, my lords.
Yes. Yes.
My lord, examination of PW1 has already been commenced in the trial court, my lords, wherein he has supported the case of the prosecution as of now. PW2 is to be examined on the next date of hearing. There is video footage to show that wherein he has accepted the fact that he has taken out this money. He is seeking time of 23 days to repay that money once a home loan is passed in his name, my lords. So there is serious allegation.
They have not even complied with 207. They have lured me to, my lords, make
You
that.
deposit the amount, we will grant you bail.
My lords, may kindly
Immediately.
see the FIR.
Immediately, if you deposit
My lords, may
Public
kindly
money.
see the allegations. My lords.
public money,
My lords, may kindly see the allegations, nature of allegations. my lords.
you have to deposit.
Furthermore, my lords, once I am granted anticipatory bail, it is the law of land, my lords, that it is to continue till the completion of trial, my lords.
Now you are in jail.
My lords, I made that.
That phase is over.
My lords, I understand that.
Anticipatory phase is over. Now you are in jail. As a condition
Well,
for bail, if you deposit the amount, we will release you immediately.
My lords, I am a clerk. I am made a scapegoat. The branch manager, everyone says that it is to be opened by 2 keys. It is not possible for me to.
You took out the cash
My lords,
for your branch manager.
no, my
If
lords.
there is CCTV footage showing you,
Not CCTV
There's no
footage. my lords,
CCTV
not
footage.
There is a private video recorded by one of the
employee,
employees, wherein he has been saying that I have taken this money. Give me 23 days time. This video is part of the investigation. This money
Out
was
of
a home
coercion,
loan.
my lords. They surround me and say, "Do you make this confession?" Because that is,
it was before the police or before the witness?
because all these branch manager, police, they
So branch
coerce
manager is
me.
not police. You could have said it is you
Because I am-
who have taken out the money, not me.
Because that conversation is supposed.
If without the presence of the police, you have made that confession, that is an extrajudicial confession
I
of
understand, my
you
lords, but
embezzling the amount.
that authenticity of.
Dismissed,
I'm sorry, my lords. May
Dismissed.
kindly consider, my lords.
dismissed. No,
Well,
public money, you have to refund it.
Let me take instructions, my lords, at least.
Then you take instructions.
Let me take instructions.
Learned counsel for the petitioner is allowed 1 week time to seek instructions as to whether the petitioner is ready to deposit the defalcated amount. Post on 9th or 11th February.
Because 9th, put it 9th, was
9th also?
9th if possible. If
9th, yes, 9th.
deep go.
9th February, yes.
Item 5.
The anticipatory bail that was granted in 2020 comes to be cancelled in 25. Admittedly, on account that I had not deposited the 6,05,000. Please see 42, page 42, my lords. I'll show 3 pages to your lordships. Are the checks the trial court before whom my learned friend's client go for the first time? There, the trial court renders a finding saying that this amount is deposited. Please see.
So was the proof.
Yes, lordship, may kindly see page 42.
No, so was that proof of deposit.
Yes, my lord, I'm showing. That's what I'm showing. Please see page 42, my lord. I'll show, my lord, page 42.
Why High Court says you have not deposited?
That's what, my lord, is an error in fact. Please see page 42. These are the checks.
No, checks are not
Yes,
deposited.
now please see.
Unless
Page,
checks are in cash.
yes, no, I'm showing that observation of the trial court at page 63. Page 61, bottom. As far this is a trial court, my lords, where they had gone seeking cancellation.
60?
61, bottom. As far as the last 2 lines, as far as the present case is concerned, the third respondent is on anticipatory bail granted by the Honorable High Court of Madras as per the orders in criminal lobby number so-and-so. On the perusal of the same, it is seen that the third respondent had been directed to deposit a sum of rupees 6,05,000 to the said committee as a condition for the grant of anticipatory bail. And on perusal of the records, it is seen that in compliance of the same, third respondent has also paid the sum of rupees 6,05,000. Not once, but not twice. At page
No,
10,
where is the covering letter of this deposit?
no, it was deposited.
Let a report. Learned counsel, yes.
But my instruction is he has deposited that amount, your lord.
Huh?
My instruction is he has deposited that amount. Now the committee is selling those properties and paying the
24 crores has been recovered till yesterday, my lords, and this thing has been made to disburse. Subsequent committee has been constituted. Money is already recovered. 24 crores as of yesterday.
is cooperating. for
Properties
the
have been
committee-
sold.
Committee, your lordship, and the properties are getting sold, your lordship, and investors are getting money.
that
So now
if that be so,
yes,
you have to pay compensation to him. Now he is in jail.
no, he's not. He's not in.
Not
jail.
in
No,
jail.
Lordship had protected me on 19th of December.
So you are guilty of perjury. If he has deposited the amount, why did you file this application
Lordship.
before the High Court seeking cancellation?
Lordship, he has deposited the check, Your Lordship.
Forget about that.
I'll ascertain.
Read page 2, first line. This petition has been filed by the state represented by so and so, Deputy Superintendent of Police,
Yes.
Salem, to seek cancellation of anticipatory bail on the ground. Then Mr. Gopinath, government advocate, says
Lordship,
that
after filing this petition, they have deposited the amount, Your Lordship. I'll file the report, Your
No,
Lordship,
no, no.
when he has deposited.
No. Come, what is the date of this order of page 63?
No, this order is dated 7th of March 2024.
7th of March 2024. 7th of March.
So the tell Lordships why this confusion had arisen.
No, there is no confusion. It's been black and white application is filed. We have to see the date of this application. Where is that application? Filed by the state seeking cancellation of your bail. Where is that application?
But originally they had filed it before the trial court, the observations of which I had shown to your Lordships. The criminal...
Don't help them.
No, I'm not helping them.
And don't beat around the bush. Show us the date on which this affidavit before the High Court was filed by the Deputy Superintendent of Police saying that he has not deposited.
66 is that affidavit.
3rd December 22. 3rd December.
3rd December 24 is that order affidavit by the Deputy Superintendent.
Where is that?
Page 69, Manoj.
Exactly. 77 last page. So that 77.
Yeah. Yes.
Lordship, I'll take instruction, Lordship, to see when the amount actually has been encashed, Your Lordship.
No, it is. See, in the teeth of order passed by the trial court
Yes, Lordship.
on 7th March 2024, saying that he has already deposited,
Lordship, yesterday I
complied with the provision. Where was the occasion for your DSP to file an affidavit in December 2024 saying that he has not deposited, cancel his bail?
Lordship, my instruction is, Lordship, he has deposited after this petition was filed, Your Lordship. I'll take instruction, file an affidavit. I've seen that, Your Lordship, page number 61.
See the date of this bank draft?
Sorry, Your Lordship.
Date of this bank draft, February 24.
Bank, no, he has given the check, Your Lordship. He issued the check, Your Lordship.
What is this? You understand the difference between check and the
Yes, Your
draft?
Lordship.
See page 42. What is this? It is indefendable. You can't defend it. Your DSP has to go to jail. Whosoever has filed this affidavit has to go to jail.
Lordship, I'll ask him to file an affidavit, Your Lordship.
What affidavit? It is in black and white. Court says it's in the order of the court that he has already deposited. And now you seek cancellation by filing affidavit in the High Court saying that he has not deposited. And you argued also and got it cancelled. Not only affidavit, you argued also and got it cancelled.
Lordship, I'll file an affidavit, Your Lordship. Lordship, I'll file an affidavit.
But if I will say something, I'm one of the depositors, no, deposit the money.
You have no role to play. You have not sought cancellation.
No, I have only one suggestion to make. Already 8 years have passed, Lord. Total of only 74 crores, Lord.
one property, they say 24 crores, it's not sufficient.
We are not concerned with your complaint or your grievance now. Now it's a different issue.
But
As to why
ultimately, we have to
a
be
senior officer of Deputy Superintendent of Police rank should file a false affidavit and can seek cancellation of bail on a false ground.
But even, even that.
You deposit now you deposit 6 lakhs.
Even that.
If you wanted to help him,
No.
now you deposit the amount.
I'm the depositor. I have to get.
You again deposit it back. Why should you poke your nose in between the court and the person?
Bro, I only wanted to say something else, not Lordship was passing any order against you. I'm not on that.
Yes.
It's not a different issue, my lord.
Yes, yes.
All I say, my lord, the money is 74 crores, my lord, with the interest, my lord. They have sold one property and got 24 crores, my lord. It's almost 8 years, my lord, and they are not selling any property, my lord. They are not doing anything. Earlier committee, this committee also for 3 years, they have not done anything. Not only property sold now, my lord. I only say, my lord, Lordship, give him some time to sell that the property is sold immediately, money is paid to us, my lord. That's only.
Is it your petition?
It's not my petition, my wife.
You go and file your petition either before the trial court or before the high court, either 226 or 482 or 528, whatever it may be.
We filed a petition in 226, which is dismissed, unfortunately.
We'll record your submission and reject it. And you understand?
I follow.
What does it mean?
I follow.
If we record your submission and reject
I
it,
follow. I will not say anything.
why should you unnecessarily make that
I
submission?
will not say anything. Not say anything.
On state's application supported with affidavit of Deputy Superintendent of Police, the High Court has cancelled the anticipatory bail granted to the petitioner on the ground that petitioner has failed to deposit a sum of rupees 6,05,000 as directed in the trial court order dated 23/1/2020.
A High Court order.
A High Court order dated 23/1/2020. Full stop. Drawing attention of this court to the order dated 7th March 2024, passed by the by the special judge special court under TNPID Act, Coimbatore, wherein it is recorded that the petitioner has already paid the sum of rupees
Lordship, may I enter for a
6,05,000. Don't disturb.
No, Lordship. Page number 42, it looks like a check, Your Lordship. It's not DD, Lordship.
6,05,000 towards remuneration by way of 2 demand drafts. Full stop. Despite this, the state moved an application on, what is the date, December?
Third December.
On 3rd December 2024, before the High Court, seeking cancellation of the bail on the ground of non-deposit. Full stop. Para. In the teeth of order passed by the trial court and the demand drafts bracket annexer P5, the affidavit filed by the DYSP is false. Appears to be false. Full stop. Let the concerned DYSP file affidavit. Let the concerned DYSP show cause as to why action should not be taken against him for making false representation before the court, before the High Court, and obtaining cancellation of bail. Full stop. Para. Affidavit be filed within 2 weeks from today. Post the matter on 19th February. Yes. Interim order to continue.
Item 6.
Now, my lord. Now the file.
Just 1 minute here. पढ़ना जरा.
Let the concerned deceased SP file show cause as to why. Action should not
Let the concerned police so cause on affidavit. So cause on affidavit. Yes,
Now the final order is passed by the High Court, my lord, in the repeat.
infractuous.
Practically.
Yes, dismissed as infractuous. Then some IA is filed.
Yes, your lord.
Some IA is filed saying that एक IA फाइल है इसमें देखना एक IA है IA for direction.
Permission to
They have filed an IA.
R1. I136451. 136380.
Heard learned counsel for the parties on IA number 136451 seeking dismissal of special leave petition as having become infructuous. Full stop. Para. Both the parties would jointly submit that the SLP has been rendered infructuous because the division bench was considering the issue at the stage of interim relief by the single judge, and now the writ petition before the single judge has already been disposed of. Yes,
Flash, your lord.
Item 7.
SLP is dismissed as infructuous.
My lords, and for the state, I seek a passover, my lords.
Please, your lordship.
Passover.
Yes, my lords.
This will go to some other.
My lord, in the meantime,
Just 1 minute. 1 minute. 1 minute. नहीं इसमें तो balance है.
it came up, I think, last week, but it didn't reach, and therefore.
वो आरोपी लगाया नहीं.
It was item 64 on there.
ये मतलब तो है और इसके बाद
ये अलग है ये अलग. सेम डेट का 15-12 का. Go to some other.
So, my lord, in the meantime, can I file counter, my lord?
Court before a bench in which one of us
Oblige, my lords.
so is not a member.
Please, your lordship.
Yes.
item 8.
Very good. Meantime.
I'm being led by the additional advocate general. He's on his legs. But however, I want to make a request. The respondent has been seeking the post of the skilled assistant grade 1, grade 2. But this post is no longer in existence. So I'm just seeking some 2 weeks time to file this.
No. He's not seeking post. He's seeking seniority.
Yes, madam, but this post does not exist. I just want to place those facts on record, my lord. I can get 2 weeks to place those on record.
So what? High Court has not given him the post.
No, my lord, the High Court has said that he should have been treated as a skilled assistant grade 2 post, and therefore he should have been promoted as grade 1.
Yes.
So as of today, after the SLP was filed, these posts don't exist, my lord.
But it is of 2019 order, my lord.
Anyway, we'll consider the effect. Let him bring the Learned Counsel for the petitioner submits that the subject post to which the respondent is seeking promotion has been abolished.
Has been discontinued. The post does not exist anymore.
No, has been abolished.
Abolished.
Has been abolished. Post of Learned Counsel prays for time to place on record some additional documents. Post of para. Post the matter on how much time you want?
2 weeks is sufficient.
On 25th February.
Published.
Item 9.
In item number 9, I am seeking 4 weeks further time on behalf of R4 to file a counter affidavit.
The management has to file a counter. That's what your lordships indicated also.
What is this?
My lord, I'm appealing for respondent 1.
It is only
These are all workmen's deals,
all
my lord.
ROPs are adjournment only.
No,
This
but
matter.
I'm pressing that this petition should be dismissed because this is only against the interim order, only on this ground that there
There's
was
no interim order. It's against an LP.
Yeah. Because these are all workmen's deals.
Workmen's dues are to be paid by the management. R4 is a management. I'm the bank. They were a debtor. They had agreed to settle the dues, and the Debt Recovery Tribunal had issued a certificate of recovery for more than 36 crores. Pursuant to a settlement, the amount was deposited and the amount was appropriated by the bank. Later, R1 files a writ petition before the Gujarat High Court stating that they should sell one of the assets belonging to the management and see that the amount is deposited, amount is given to them. That is taken up right up to the Honorable Court inter alia on the question of jurisdiction. There is a remand back. Sorry.
Management is your borrower.
Management is my borrower. Otherwise, I don't have anything to do with the work.
Your dues are paid or not paid?
No, paid.
Now paid.
Paid. Not now, my lord, it was paid earlier.
For you, it is infructuous.
For no. Then what they do is that the High Court then passes an order.
Why, if your dues are paid, why are you here?
I am here, my lord, because they went to the High Court asking for,
means?
My lord, the workmen.
Not
they
against you.
No, I was also there. I was also made a party.
What relief is claimed against you?
The relief inter alia claimed is that the amount should be recovered from me and then deposited, my lord, in the industrial tribunal or in the court to be appropriated by that. The management is to pay that. That's why, my lord, they have been seeking time to file a counter affidavit.
No, my lord, I am not the management. R3 is the management. Reason being, R4 has sold this factory in 1989.
Yes, they are right.
And the dues are with respect to 98.
Workmen.
Kindly see page 24, my lord.
Dues are the first charge.
That's correct. Not against me. And the amount is.
But it is paid to you without certifying their claim. It is.
I am not the purchaser of the property. I am not the purchaser of the property.
No, but you are receiver of the amount.
Yeah, much earlier. Pursuant to a certificate of recovery issued by the Debt Recovery Tribunal. Let them file an affidavit, my lord, so that your lordships have a clarity.
How much time you want?
I am 4 weeks time.
Why are you taking so long?
My lord,
2022 matter.
Let me explain. My lord,
Who are you?
I am for R4.
Management.
No. I have sold.
Who is R4?
I am unnecessarily pleaded as a party. Reason being.
Who is R4?
R4 is ACC Limited.
Yes.
He sold the factory in 1989.
You have purchased it.
No. We sold the property 1989 to R3. R3 defaulted in payment of workman dues in
There is no order
1998. After 9 years.
There is no order against you. Why should you file?
No, yes, the labor court has deleted us.
Yes.
But unnecessarily been implemented by these parties.
1 week, file in 1 week.
My lord.
You have nothing to say in the matter.
2 weeks.
ACC is not in the picture.
2 weeks, my lord.
Unnecessary, you are saying
2 weeks.
4 weeks. 2 weeks.
Very good.
My lord.
Post on 17th February. 17th February.
Great.
But now that your lordships are, please give us time to file a rejoinder to R1's counter also.
1 week.
We'll
for
do that in the meanwhile.
1 week thereafter for rejoinder.
Very good.
Tell us some date again.
24th,
Please, your lordship.
24th February.
Great, please.
Lord, I appear for the petitioner.
Yes.
Lord, here we are running a shadi.com.
Sadi.com, yes.
How, Lord,
Sadi.com.
we have nothing to do with this. I mean, they meet thereafter. They come together. Thereafter, she advances some loan. What have we got to do? We are only a matchmaker.
Yes.
And the police, Lord, arrested one of our executives and then against MD a notice is issued. So therefore, your lordship.
You are MD.
I'm the MD.
And I am the 2
And
employees.
the 2 employees. And 1 employee was already arrested. He was released on bail. And they are calling us, Lord, it's so obvious why it is done. And now if one sees their counter, it's shocking. They say you're not complying with 79 of the IT Act and all that. I fully complied if one sees my questionnaire. And IT Act has nothing to do here. This is a case of cheating where they meet thereafter. And please see the WhatsApp messages. Even in the FIR, I am not named.
You are facilitating the fraud. That is what they say.
No, facilitating means to what extent? I am facilitating the matchmaker. Tomorrow it can't be. Tomorrow some offense takes place elsewhere. I am the matchmaker. I can't be allowed to do this one.
So you should
Please see the FIR. Please see FIR. There is nothing else.
screening before arranging
I
meeting.
want to interject the senior, my lord. Please have the impugned order, my lord. The impugned order is that they have stated that I will cooperate with investigation. Not they are asking for quashing, my lords. It is, my lord, a submission by them.
Petition is for quashing.
Please have, my lord, page 2 of the order, my lords. Learned counsel for the petitioners would submit that though the petitioner are determined to see the process and the alleged offences are punishable with an imprisonment of so and so, the petitioners are apprehending coercive measures. Learned counsel further submits that the petitioners are ready to cooperate with the investigation, hence paid for necessary directions.
Look, please see para 6. It's a notice under 35(3), which is to the accused.
My lord, they have conceded. The issue is that they have said that they will cooperate with investigation. On their asking, my lord, the petition has been disposed of with the direction that 35(3) notices will be issued to everybody, which is akin to 41A of CRPC, my lords. Now, when they ask for this, my lord, today they have not even argued 79. They have not even raised the issue of intermediary before the.
So we have not considered any
submission that was there is that we will cooperate with investigation.
That I'm saying now also.
But they are asking for quashing of this entire FIR, my lords.
Against me.
There is an issue here, my lord, which we were pointed it on our counter, that in this particular case, they lose the protection under intermediary provisions of IT Act, my lord, because a relationship manager was assigned to this complainant herein, who went and gave the profiles. What profiles do you need? He has done the filtration. When there is
go and meet outside,
my lord, the intermediary protection.
But please have a look at the FIR first. Please have a look at the FIR. I'm not even named, told or anything. They only said that we met on the shadi.com portal. That's all. And later they chatted on the WhatsApp. And then they met in the real world, and thereafter all this happens. Please see note page 95, FIR. Page 95.
Why did you not press it on merits in the High Court?
No, Lord. We pressed on the merits. The learned judge said you cooperate with the investigation. We are doing that. We have no problem about it. But as an accused, the notice is as an accused, 35(3). And why am I an accused? Please see Lord page 95 for a minute. Page 95, your lordships have got, Lord. The conversation commenced on January 30, so and so. Mobile number he expresses.
What is paragraph 5
of Lord, the order?
Of the impugned order?
Yes. But that is under 35(3). 35(3), I can't be an accused. Please see the FIR.
That is under 528 BNSS.
Yes.
Not 35(3).
No, under say any notice under 30.
Your petition
Is for quashing.
quashing.
Quashing. Correct. Fine.
But you did not pray for quashing in para 5.
No, I have prayed. Lord.
Here is that submission in the court. It's an open court order.
Lord, the order doesn't record that. How can I am not?
You should object to it.
So therefore we filed this SLP.
You cannot take a goody prayer in the High Court.
But please see the first prayer. Please see the first prayer, first para. These criminal petitions are filed under seeking quashment.
What is the matter about? Not your submission.
Yeah, correct.
This is recorded by the court.
Lord,
That
pressed-
is the petition under 226.
Lord, we pressed for quashing.
But your submission is para 5. Learned counsel for the petitioner submits that though the petitioners are determined to see the process through and the alleged offences are punishable, so and so, police concerned have not issued 35(3). That is your grievance. And as such, petitioners are apprehending coercive measures. Counsel further submits their petition ready to cooperate with the investigation. Where is the plea?
Was for quashing. It can't be, Lord, we file for quashing and then don't request. Lord, please have a look at the
No, it
FIR.
happens in so many courts. It happens.
Lord, I'm
And at
pressing
that
for
stage, we only want this. We only want this. And
No, I'm pressing for quashing. In fact,
go and press there.
but then your lordship may protect me in the meantime. Your lordships have already granted protection. Continue that protection. I'll press that again. In fact, I had in fact asked for quashing. I filed the
Your counsel who appear, who are trying to please the judge.
Lord, your lordships know it much better. Both my lords.
No, but
Both my lords
we
know.
don't want to know in black and white. When something is recorded in court proceedings,
Correct. There's no doubt about it. But
yes, we cannot say that since we understand that this is happening in different high court, therefore FIR is quashed. Without you pressing it in the high court.
no, obviously, that is not the.
Then everybody will come here.
Lord, your
Half of the relief there and half of the relief here.
Lord, I quite understand that. Lord, please have a look at page 95 for a minute. The lady doesn't even say anything against me. Please see page 95, Lord.
You are right, but say so in the high court.
And it is Lord, you remand it. I'll remand it. I'll go back. I'll go back to the high court. We'll go back to the high court, please. Permit us to go back. Permit us to go back. We'll go back and.
Approved the High Court taking quashment of the proceedings in crime number 140 of 2025 on the file of Jubilee Hills Police Station, Hyderabad. However, the impugn order passed by the High Court has not recorded any such submission made by the counsel for the petitioners on the merits of the quashing. The only statement, the only submission recorded, the only submission made by petitioner's counsel is recorded in para 5 of the impugn order, which is reproduced hereunder. Para. When the matter was argued today, the Natkani and Sri Gaurav Agrawal,
Second matter.
Learned, there are two matters.
Two matters.
Learned senior counsels appearing for the petitioners would submit that the petitioners have argued the quash petition on merits. Full stop. Para. Be that as it may, comma. Since the quash petition has not been decided on merits, comma, we set aside the impugn order and remit the matter back to the High Court for consideration on merits. Full stop. Accordingly, criminal petition number 5566 and 5567 of 25 in the High Court of Judicature for the state of Telangana at Hyderabad is restored to its original file. First off, the same shall be dealt with by the High Court on merits. Full stop. It is made clear this court has not expressed any opinion on the merits of the matter.
Lord, para 7 of the earlier order may be continued. Lord. Say, who are the petitioner?
26 June.
26 June order. Who are the petitioners? That is fine.
No, it is the FIR in the state.
That's right.
FIR
All
was
for us.
So that was missing, but it was clarified.
It was
only make one, and I leave it to my lords totally.
In the meanwhile,
They will cooperate with the investigation. We are not taking any coercive measures. That was their submission.
in the meanwhile, petitioners shall make a prayer for grant of interim relief before the High Court. In the meanwhile, petitioners shall make a prayer for interim relief before the High Court until such prayer is taken up for consideration. Full stop. Shall file an application for interim relief before the High Court. Full stop. For a period of 8 weeks from today, no coercive steps shall be taken against the petitioner.
Obliged, grateful, highly grateful. Obliged.
Most obliged.
Chief, item 11 and 12 already mentioned in the morning.
Yes.
Please, my lord. My lord, at the outset, my lord, I would.
652 days.
Besides this, my lord.
Why have you filed this petition?
There is one more difficulty, my lords. In fact.
No. Why should you file this SLP?
My lords,
your earlier SLP is dismissed. You should be settled with cost, exemplary cost. At least 1 crore.
My lords, please just allow me to.
At least 1 crore.
Please
read the order of the High Court.
Yes, my lord. No ground is made to review the order of the court dated so and so, especially when the SLP number so and so state versus Jaising Sani and others filed against the said order has been dismissed by the Supreme Court on so and so, and the review filed by the state for review of the order dated so and so has also been dismissed. There is delay of 5502 days in filing of the instant application, which is.
What is this happening? Who advises your government?
My lord, sir.
Who advises your government to file SLP?
Well, Jaising Sani case was filed, and the concerned department was waiting for the outcome. This is what
No. You should pay cost.
Exemplary
cost.
No. Lordship.
SLP dismissed, review dismissed, delay of
not in this
days.
Not in this
and
case.
Then again SLP is 52 days.
No, my lords, not in this case.
Similar order. Similar order. They relied upon order. They relied upon order.
But the High Court has.
No. We can't allow this.
Lordships may.
We can't allow SLP filed only for the sake of filing. It is not only a frivolous case, this is a vexatious litigation. Not only in the High Court, in this court also.
If your lordships would.
High Court, you file this review with the delay of 5,502 days.
That's because the other litigation was pending before.
We do not know. We only know that your review is filed 5502 days delay. And moreover, the SLP against the main order is already dismissed by the Supreme Court way back in 2016. And a review against the said order has already been dismissed by the Supreme Court.
Lordship, actually, Millers on merits, Millers, and Annexure P4 is there is a 3 judges bench judgment of this honorable court.
This SLP is barred by 652 days. Full stop. The order under challenge passed by the High Court records thus: para 1 and 2 record छोटा सा है. Full stop. Para. In the teeth of what has been recorded by the High Court, comma, it seems, it is apparent that not only the earlier SLP has been dismissed, earlier SLP has been dismissed in the matter of State of Haryana versus Jai Singh, but review petition has also been dismissed, and thereafter the instant review petition was preferred before the High Court with a delay of 5502 days. Full stop. Para. The present SLP is not only frivolous but also vexatious. Full stop. It is sheer wastage of court's time. Full stop. It is surprising as to under whose opinion the state was advised to file this SLP. Full stop. Para. While dismissing the SLP on the ground of delay as also on merits, we impose cost of rupees 25 lakhs on the petitioner to be deposited with the Supreme Court Mediation Center and the Supreme Court Legal Services Committee within a period of 4 weeks from today.
Lordships, kindly, merits 25 lakhs, my lords.
Yes, lakhs. We understand the
I humbly
understand the difference between
Millets,
thousand and lakhs and crores.
Millets, I humbly request, Millets, kindly waive off the cost, Millets. Lordships, in this, this was not in this case.
What's the next case?
Millets, in that case, Millets, kindly permit us to withdraw, Millets.
No.
Kindly permit us.
No.
Millets, it would be.
Read the pass.
Millets, I
hope you read the impugn order before standing on the dais when the matter is called out.
Please, Millets, I was just signed this yesterday only, Millets. I have read.
No. From yesterday till 10:30, how many hours?
Millets, I have read this. Millets, I appreciate.
If you read.
Millets, kindly permit.
No, we are not doing that. Simply rejected. Call the next case.
Lordships, at least.
Call the next case.
Kindly waive off the cost.
30 lakhs. Make it 30. And next year it will be 35. Yes.
Making a request for a passover, my lord. I'm led by Mr. Roach. This matter was listed on Wednesday, my lord, when your lordship was pleased to.
Yes.
Look, may I make a request subject to the other side? If the matter will be taken up at 2 p.m., my lord, because, otherwise, it's a fresh matter, the eviction order.
Rejected.
Passover.
Yes.
My lord, the arguing counsel is on his legs, so kindly adjourn the The arguing counsel is on his legs, so kindly adjourn the matter.
Adjourn or Passover?
Adjourn.
He will be on his legs throughout the day.
You can give Passover.
Yes. If you want adjournment, the first sentence would be different. Passover. Let us see.
Item 16.
Wait, please. Lordship, these are two connected cases. Lordship would recollect on the last occasion when your Lordships had heard the matter, your Lordship had indicated that your Lordship would like to hear it in details. The trial court record has been summoned. We are prepared with the matter. There's a short note for your Lordship's convenience.
Record has come?
Yes, your Lordship's record. Short note for your Lordship's convenience. Just for the sake of pagination, may I request your Lordships to have the 16.1 file, because our file is paginated in terms of, the note is paginated in terms of that. They're connected matters, same impugned order, but for the sake of convenience, and just stating that. Your Lordships, there are concurrent convictions in the matter. The person has suffered around 13 years and
The basis of the conviction is twofold. One, the aspect of, I'm just laying out the outline before I move to the facts. The basis of the conviction is resting on a few pillars. One about the, sorry.
And move. Very good. Mhm. We build the.
In which case, Your Lordship, since I understand Your Lordship, board is heavy, the person has served around 13 years. In case, if it meets with Your Lordship's approval and it's a legal aid case, would Your Lordships consider either having a short date or if Your Lordships feel
No, we'll give you a short date.
You are comparing with Hakam Singh.
For both Your Lordships, Hakam Singh and Bawa Singh.
Both the matters are here.
Yes.
They are brothers, my lord. They have killed their third brother. Interim was, my lord, specifically declined, my lord. He was specifically declined.
Only one eyewitness, that is Bola Singh.
Bola Singh is eyewitness, my lord. Medical evidence is also there, my lord. The fingerprint expert is also there, my lord. Report is there, my lord. And recovery on the
senior colleague wishes to open the case, then
no, I'm just because my learned friend has given the
to meet it.
No, I'm not. I'm just
the respondent should not open their case before I have.
I'm just giving the details because
Sir,
the note has already
your best to already put me in a precarious position.
We'll take it. 24th?
Certainly, Your Lordships.
You want it back, this your submission or?
In whatever is
better. Because sometimes a different file is circulated to us by the registry.
Would Your Lordships want us to e-file it for Your Lordship's convenience?
That would be better.
Certainly. We'll do that.
Course on 24th.
Please, I come from Chandigarh, my lord. Has directed me to come from Chandigarh physically, my lord. I'll again come, my lord.
This is Punjab or Haryana?
Punjab, my lord. Punjab, my lord.
Punjab.
The other matter was from Haryana.
Please, my lord.
Yes. Where Your Lordships took us turn.
Yes.
Highly grateful, my lord.
Item 17.
Grateful, Your Lordships.
Your Lordship, in this matter, service is complete. Your Lordship, I issued notice on limited to quantum of sentence.
Lordship, we would like to file counter affidavit.
Quantum of sentence?
Yes.
Yes.
This is case of gang rape of a referendum.
What quantum?
Your Lordship has issued limited notice because 25 years was given this is a legally matter. Your Lordship has issued notice on 9/9/2025. Issued notice.
They have spent only 5 years, 9 months.
It's from 2019, my lord. 7 years, my lord.
7 years.
7 years.
As of now.
As of now. My lord can list it after for final hearing. Because there will be more time. Only thing, the victim evidence, my lord, I can show it to him. When they ask in the cross-examination, she is not able to identify. She is not able to say.
Mentally retarded girl. Deaf and dumb.
Mentally unstable.
Only deaf and dumb.
Yeah, deaf and dumb.
Deaf and dumb.
High Court records that she is mentally unstable also.
If I show you the evidence at 105, my lord, it starts at 105.
105?
It starts, my lord.
And DNA sample is conclusive at 76.
My lord, page 107, question number 6. On cross-examination starts from 107, your lordship. On being questioned by the defense advocate. 107, question number 6, last bottom. On being questioned by the defense advocate, speaker admitted that the statement of the witness under 161 statement was recorded in his presence. Did 4 or 5 other people come when you asked them to take you on the motorcycle? On being asked in this regard to the preacher, the preacher said the witness is unable to tell. It was dark at that time. You did not recognize anyone. The witness answered 108. The witness is not responding to question asked to the instructor in this regard. Description sheet says the instructor went there. Had you not, my lord, then you 108 down, my lord, I'm reading question. Did nothing happen to you? In this regard, when the preacher asked to the gesture, the witness indicate by showing her hand, which preacher the witness saying the incident has happened to her. was the incident of assault on you. The witness is describing the fight by gesture, is pointing toward the feet. The preacher told that she is narrating the incident of fight. You had not seen the accused before today. When asked to the gesture by the enlightened, she indicates with the speaker says the witness is telling she's seen it before. Rather than the cross-examination by Vinay Pandey, question number 7. What time did you go to the market? The answer, the witness is not saying anything when asked through the gesture by the speaker. How did you read the incident spot Parihit Ghat? When the witness is asked by the preacher through the gesture, the preacher says the witness is not answering. Who took you on the motorcycle? Witness gesture on the witness and asked. The witness is not giving any answer. Have you ever studied in school for the deaf? The preacher asked the witness by making a gesture, to which preacher said the witness is saying that she is not educated. You are not able to understand the gesture of the preacher. When asked by the preacher to gesture, the witness is not making any gesture. Preacher says the witness is not giving any answer. The defense asked preacher whether the witness is mentally weak apart from the deaf. In this regard, preacher said that I am not a teacher in a deaf school. I cannot tell about the mental weakness. But then, if you like, I can read the last question in this way. Do you work for begging? When the preacher asks by pointing the witness point, the preacher says the witness is denying. Did you go to beg on date of the incident? The preacher asks by making gesture. The witness shakes her hand, indicate on which preacher says the witness is denying. So she denies that she has not gone for begging. And the case on the FIR is throughout that, my lord, that she has gone for the begging. From there, these people have picked her up. You at home on the date of the incident, preacher is giving the answer to this question by gesturing. Preacher says the witness is not giving any answer. The person with whom you have come to give the statement today, has he explained to you about giving the statement? When the preacher asked, the witness with gesture nodded her head with gesture, or the preacher said witness is denying. The defense lawyer asked speaker that when the witness was giving a statement in front of the police, she did not name anyone. The speaker accepted this fact that when the police she did not name anyone. When speaker was asked about the victim's statement was recorded in his presence at the police station, speaker accepted it. The said statement was recorded at 6:30 in the evening. When asked, the speaker accepted that not every fact can be understood by the gesture. There's another cross-examination by the other accused. At page 113. Then there's that's all, madam. That's the 112 only till there, the cross-examination. Madam, in that.
He identifies you in the doc.
RPC that they were already identified by them and then that was type was done. But that, yes, my lord, in the cross-examination, that pointed out with regard to the underwear part where there's a DNA was matching at page 92, witness number 4, my lord, the brother of this thing.
Everything she states in paragraph 1 and 2 and paragraph 3 in the detail.
Madam, that's why in cross-examination she is not able to say anything. That's why we are saying there's a preacher is saying this. There's a mental condition.
You have not read the entire one.
Yes, page 105, my lord, you are saying.
108.
Were you sitting at the bridge from there on, madam?
Last question.
Did nothing happen to you? In this regard, the preacher asked to gesture the witness in this case by showing her hand, to which preacher says the witness saying the incident has happened with her.
Yes.
Was it?
Next page.
I read this, madam. Was the incident of assault on you?
Yes.
The witness describing the fight by gesture is pointing towards the feet. The preacher told she is narrating the incident of fight. You have not seen the accused today. When asked to the gesture by the enlightened, she indicates to the speaker said witness is telling.
What more you want from a deaf and dumb woman?
She has seen it before.
And Lordship 76, DNA opinion is very conclusive.
But on PW4, my lord, the DNA on the
76
is 92 of the brother.
What on sentence?
25 years, my lord. 376D, gang rape, 25 years.
Minimum is?
20. Minimum is 20.
You can reduce to minimum. Only that much you can do.
Minimum is 20, my lord, I've checked. 376D.
Lordship may then convert it to without remission if 20 years.
No, 25 is with remission or without remission?
There is nothing about remission.
Where is that part of the trial court order?
I'll just
Sentence part?
177, Lordship.
The my lord starts as
173.
173.
17.
Under 172, para 56. Each of the convicted should be sentenced to 10-year rigorous imprisonment and fine of 1,000 for the offence under 366, and 1 month rigorous imprisonment in default of payment of fine amount, and 1 year rigorous imprisonment and fine ₹500 for offence under 342 IPC, and 1 month rigorous imprisonment in default of payment of the fine amount, and 25 years rigorous imprisonment and fine of ₹500 for offence under 26D of IPC.
No. If we say without remission, that it will in fact enhance the sentence rather than reducing it.
Yes. I was arguing the similar.
Because if it is with remission, 25 years, then with remission he may be released in 18 or 19 years.
19 years.
Yes. But if we say 20 years without remission, that means it is more than what trial court. It will not amount to reducing the sentence, but increasing the sentence.
In this case of gang
We will not say anything about remission.
My conduct is good, man.
We'll-
This is the only case against me.
We will not say anything. If I could 20 कर देंगे बस. Take. Leave granted. All the appellants are here. All the accused.
All the accused were here, man. Two have taken no objection.
What's the problem with the state of Chhattisgarh? That is, its
The present appellant
policy allows one to be take advantage after 14 years only.
The present appellants have been
Lordship is aware. Lordship is aware.
have been convicted for committing offence punishable under section 366, 342 and 376 small d IPC and have been sentenced to undergo RI for 10 years, 1 year and 25 years respectively for each of the offence. With fine sentence also. The conviction and sentence has been handed down for committing gang rape on a deaf and dumb woman. We have seen learned counsel for the petitioner tried to while entertaining this SLP on 9/9/25, we issued notice limited to the quantum of sentence. And as such, in the present order, we are not dealing with the merits of the matter. Full stop. At the time of commission of offence, petitioner number 1 petitioner number 1 Sanjeev Kumar, petitioner number 3 Dole Dole alias Mithun Kujur, and petitioner number 5 Gauri Shankar were aged about 20/21 years. petitioner number 2 भी लिखते हैं. petitioner number 2 Suraj Das, चारों का ना 1, 2, 3 and 5 were aged about 20/23 years. Whereas petitioner number 4 Krishna Kumar was aged about 35 years. Full stop. They have already suffered incarceration.
2019.
What is the date of their arrest? On the date of their arrest, that is
27/8/2019.
27/8/2019, and have thus undergone more than 6 years of jail sentence. Full stop. The trial court, the minimum sentence provided for committing an offence under section 376 bracket small d of IPC is 20 years. Whereas the trial court has awarded imprisonment, rigorous imprisonment for a period of 25 years. Full stop. Three of the considering the age of the petitioners at the time of commission of offence, and for the fact that three of them appear to be tribals. three क्या सारे tribal होंगे. Hudur is tribal, then Urao is tribal, number 5. Number 2 also maybe. Three of them are tribals. 4 नहीं होगा. 4 नहीं होगा. जो Urao है.
20 or 20. It's 170.
We are of the considered view that ends of justice will be served if the jail sentence awarded to the petitioners, apparently leave grant कर दिया है सब जगह, the appellants is reduced to the minimum provided for an offence under section 376D of IPC. Full stop. Accordingly, the appeal is allowed in part, and the jail sentence awarded to the appellants for offence under section 376D of IPC is reduced to RI for 20 years. Full stop. The other jail sentence awarded to the appellants shall remain intact. Jail other sentences and remain intact. Yes, next.
Only one submission also. Only one submission. Petitioner 4 and 5 had taken no objection from us. Like 4 and 5, they engaged their own separate counsel. It's a legally matter. But 4 and 5 had taken no objection, but they are not represented today. They are advocated.
We have passed an order in their favor.
Just informing your lordship.
We have not dismissed. On the date when we issued notice, you were holding the brief.
Yes.
And on that day, we have dismissed the appeal on merit.
Yes, madam.
Notice issued on quantum only.
Quantum,
and on quantum, we have passed an order in their favor.
They were favored. That's all.
So there is no adverse order in their absence. Yes. Yes.
May it please your lord. On the last occasion, my lords have directed the trial court records to be brought. It has already come, and I don't know whether the council is there. It is clearly on the last same theory. It is done.
उनको बुलाना वो प्रज्ञा बघेल को. Call her, Miss Bघेल.
राजस्थान ना.
उनका स्टेटमेंट लिखा देंगे कि तो उनका अपीयरेंस सबके लिए आ जाएगा ना. She has already given an NOC. में लिखा ना. के बाद Who has taken NOC from you?
4 and 5, this petition 4 and 5.
Ms. Pragya Baghel, Learned Counsel, submits that although the present SLP was filed through Supreme Court Supreme Court
Legal
Aid Committee,
Legal Aid Service Committee.
Legal Aid Services Committee, since after issuance of notice in this SLP, the petitioner number 4 and 5 have taken no objection from her. Today, no one appears for petitioner number 4 and 5.
The advocate on record name.
Your colleague is here, standing behind you.
No, she was saying your advocate on record name is there, Mr. Nirmal Chopra. Advocate on
He has
record.
filed.
His file Bakadama. Right. Name is showing in the office report.
Mr. Nirmal
Chopra.
He is Dr. Nirmal Chopra.
Dr. Nirmal Chopra.
Dr. Nirmal Chopra has filed his Wakalatnama for appellant number 4 and 5. However, he is not present when the matter is called out for hearing. Full stop. Considering the nature of order, we propose to pass today. We consider fit to adjourn the matter in the absence of counsel for appellant number 4 and 5. उसके बाद फिर बाकी करेंगे. Yes.
If you wish, should I just inform Mr. Nirmal Chopra, Dr. Nirmal Chopra to mark his attendance?
Inform him if he appears. We'll delete that part and say that we have also heard him.
Yes, sir.
Yes.
We'll do that. Yes, inform him.
Or otherwise, we propose to appoint your friend as amicus.
Okay.
But since Dr. Chopra is appearing now, yes.
Much obliged.
Minutes, the reports have come from the trial court minutes.
There is a letter for adjournment.
The state has moved the letter. 1 week time for counsel.
Your letter?
Yes. She was not informed also.
It's 18.
18.
Actually, 13 years and 8 months is already undergone.
Just a week's time,
Yes.
That's all.
Yeah, it's fine. No.
As paid by counsel for the respondent, post after 1 week.
Grateful Lord.
Please, my lords, I pay for the petitioner.
Pay, please, my lords.
Yes, letter by respondent. 19.
Sorry, 20.
19. I for the
yes, letter adjourned.
letter. Please, Lord.
1 week पर करना 2 week का adjourn. 1 week लिखा है 2 week का adjourn.
Please, your lordships.
Yes.
Lordships, this is a transfer proceeding of a maintenance proceedings from Hisar to Delhi, your lordships.
What was the report of the tribunal has come?
On the last day,
Yes, my lord.
we proposed that why can't it be to a nearby district in Haryana itself?
In Haryana,
But-
there is some difficulty, your lordships.
What difficulty? Haryana and Delhi, same difficulty.
Your lordships may, once I narrate, I think the facts. it
So
will-
we understand.
Yes.
We know everything about this.
Yes, but your lordships, we feel.
You are gay
Yes,
and your parents are troubling you
Yes.
because of your sexual
orientation.
That is the 3-line case.
Yes, but
Yes, my lord.
look at.
Need not be argued.
Yes, but your
My
lordships.
lords, all we want is, my lords, some conciliation, and this is what the report also records, that he was called for conciliation purpose. We don't want any fight, any trouble, nothing, my lords. He is my son, my lords. Why would I be against it? We
Let
just
it
want
be to a nearby district.
this only reconciliation purposes.
You see,
Say this.
you must understand, when they receive the news or get an idea of your orientation at the beginning, there is always some reaction. But by lapse of time, they try to reconcile with the newly found fact or newly found.
We have withdrawn the other suit also, my lords. We just want harmony in the family, nothing else, my lords.
Your lordships, may I suggest this? I've taken instructions from my client. He is willing to go through a mediation proceeding, subject to the fact that it should be through video conferencing. If that is so, we are agreeable at least to make that effort. Because I quite see what
Yes.
let it be in the Supreme Court Mediation Center.
My lords, the parents are old. They both are retired.
So they may also come through video conferencing.
My lords, one thing, my lords, as the proceedings under the Act, my lords, it says, because as per the report of the tribunal, what the tribunal has said, that they had called him only for the purpose of mediation only. He was directed not for contesting. The only order of the tribunal is, and it has been attached by the tribunal, he was called for reconciliation.
But
My lord,
personal
for reconciliation.
Now, if he was called for mediation.
For mediation under the
he wants a mediation.
Yes, my lord. For
Why
mediation
should
under
go
the
for
Act.
mediation?
But let it be. The proceeding is pending here, your lordships. Let it go to the Supreme Court Mediation Center. Let them also appear through VC. I'll also appear through VC and make.
But if you can appear through VC here,
Yes.
Yes,
you can appear through VC
anywhere.
Chandigarh Mediation Center also.
Yes, today the issue is, your lordships, even till today, the link of
Transfer petition is rejected.
Just hear me. Your lordships may just hear me for a minute.
No.
Your lordships.
You appear to be a rigid person now.
No, not.
How? Since you are feeling that law is probably on your side, you are taking it rigidly.
Your lordships.
Dismissed. No. We have dismissed your petition. No.
I have
No.
once.
No, we are dismissing your.
Your lordships, may I just say?
Go and fight it out. Go and fight it out.
I just say one last thing.
If you are the son, they are also your father.
Yes, absolutely.
Yes.
That is precise. Your lordships.
Just wait.
Yes.
Don't run away. Yes. Yes.
May I just say this?
Mediation at Chandigarh Mediation Center through virtual call. Through virtual mode. Yes.
Let there be through virtual conference.
My lords, there is an apprehension, my lords. The boy is, my lords, in hand of some persons, my lords. And he is not coming out. So therefore, my lords, there is a very apprehension that they would be using deepfake technology, my lords, during his mediation also. My lords, that is a real apprehension.
Your lordships may not say
Let
that.
my lords
Let
be
it come
called.
to the supervision of the
Madam, kindly.
No, let me
Madam, let
complete.
him be called. My lords, what has happened? He is in hand of some persons, my lords, and he is playing in those hands. We just want, let him come in person for mediation. Why no, madam? We are his parents.
I know.
We are not asking for anything else.
Habeas corpus petition. I was
See,
confined.
No, madam. Please don't say so.
Because of the orders of
See the orders of the High Court.
release.
Forget about that. Now there is no habeas corpus issue.
Your lordships, let it be Chandigarh Mediation Center. I have no.
No, rejected. Transfer petition rejected.
No, your lordships may.
Transfer petition rejected. No.
Just bear with me, your lordships. Today I.
Fight it out. This is only a transfer petition.
But today, may I just say one last thing?
Go and fight it out.
Yes, let me just say one last thing, your lordships. Just permit me, your lordships. Your lordships on the first occasion was pleased to issue notice and said the proceedings today. I am completed my PhD. I'm in the US. I am in the process of getting a job there, a fellowship. They have been writing consistently to, in fact, ensure my deportation from there. Today, your lordship knows and your lordships has read the file. I am willing to take a middle path in this. Your lordships are not inclined to transfer to Delhi.
Who is stopping them to go to US or anywhere else?
No, let it not even be transferred to Delhi. I let it not even be transferred, but let the one thing I can say, your lordship, my request is, let them give me a video conferencing link at least. Let that link be given so that I can appear. Today, what has happened is, there have been 9 proceedings before the tribunal.
Why are you avoiding to meet your parents?
No, I came here, I was confined. Why did I?
Yes, rejected. No. No. I will not hear even a minute now. Yes, call the next case. No.
Link, your lordship.
No.
That can be given.
No.
Provided.
We respect your sexual orientation, but at the same time, you must respect your parents also. Yes, rejected. Don't argue now. Rejected. Call the next case. Who is the next? Item number 21 dismissed. 21 dismissed. 21 dismissed. Yes, you are 21. Yes, you are start arguing. We are not hearing you, ma'am. Please.
Because this is a transfer petition for
Yes.
life. The distance is about 530 kilometers one way.
Yes. Respondent is served, not appearing. Allowed. Transfer petition allowed.
Item 22.
Please, this honorable court. My lord, despite service.
Yes.
Fellows, despite completion of service, there is no appearance on behalf of the respondent husband.
Yes, service complete, no appearance allowed.
I'm so grateful, my lord. So obliged.
46.
Yes, madam. Out of total sentence of 15 years, the petitioner has already undergone 8 years of the total sentence, my lord. My lord, appeal is filed in 2021. The earlier suspension of application was rejected in 2021. After 4 years, my lord, appeal is not likely to be completed in near future. And my lord, the two independent witnesses, Rohit and Lalit, my lord, Rohit has not been examined. Lalit has not supported the case of the prosecution, my lord. My lord, even the information.
Second conviction.
Yes, my lord.
Yes.
My lord, but I have undergone, my lord,
Yes,
out
7
of
years.
8 years, my lord. 8 years I have already undergone.
Yes, now only 2 years remaining.
No. 15 years is total sentence.
Yeah, 15 years total.
Yes.
And then sentence because of your previous conviction.
Correct, my lord. My lord, that appeal of 2011, still it has not been heard.
Fit for suspension of sentence.
Yes, my lord.
Not fit for suspension. Sorry. Not fit for suspension of sentence.
My lord.
This is second conviction.
I understand.
Yes.
But
you are habitual.
No, my lord.
Things are different when you are habitual.
In this case, my lord.
In this case, earlier 5
information was received.
In the second attempt, the kg increased.
It was 5.
Earlier it was small or intermediate. When you became bold enough.
No, my lord. My lord,
Now
only
you
consider
became commercial quantity in the second attempt.
two independent witnesses.
Dismissed.
My lord, in that circumstances, my lord.
Dismissed.
My lord, in that circumstance, may I liberty to renew after some time, my lord, if appeal is not being heard.
No. Yes.
Well, then I am permitted to withdraw.
Yes, dismissed as withdrawn.
I am deeply obliged.
Yes, Mr. Digital Arrest.
This petitioner is a 27-year-old student.
Sorry.
No, may I just indicate, this is a classic case where the complainant side has become an accused and the arraigned accused made a witness. May just kindly come to the High Court order itself, page 2.
I have read the entire order.
High Court says the main accused.
Word by word.
Yes, I want to show that word.
Yes.
Kindly come to
the High Court has noted.
Yes, the main accused
is Krishna Kant.
And he has been.
But you took the
Krishna Kant stay for us.
There and you are his relative.
No,
you were helping him.
May just be. Krishna Kant,
everything,
as per the High
laptop,
Court,
mobile, everything. It's a case of digital arrest.
That's what I'm saying.
Somebody becomes DYC,
Yes.
somebody becomes
no.
so
High
and
Court
so
says,
from
may
SP and DYC.
just indicate words. High Court says
sometimes DIG, sometimes DYC.
But that's the main accused, Jurel. That's the IO who claims to be IO. But before that, can you see page 6, para 2? State says that it is the main accused, Krishna Khan, against whom the recovery has been made. High Court, in caution of Krishna Khan, itself states this order of arrest, my lords. Kindly come to that order, my lords, where the state considers nothing against me, my lords, and Krishna Khan is the main accused. High Court, my lord, stays the arrest of Krishna Khan in a caution petition in the same FIR. That order I have also annexed, my lord, at page 41.
We are not concerned with that.
No, my lord, I am not named in the FIR at all, my lords. The person who were arraigned as an accused.
High Court has committed a mistake by saying the arrest of Krishna Khan.
Because, my lord,
we will not commit a mistake.
But there is nothing against me. Just saying I am a law student.
I have seen it. I have seen it.
But just see the FIR.
Cyber fraud.
Well, I am a law student. First year law student, 27. Well, of course, a digital arrest. But the real perpetrators have been made witnesses, my lord. May just, my lord, kindly just bear me for a moment, my lord. Even the charge sheet which has been filed itself says that the main perpetrators have already received the benefit. Lordship, it is the charge sheet itself. Kindly come to page 153. Charge sheet filed 5 months of custody. 1 year, first year law student, my lords. Kindly see page 153. 133. The persons who have received the money have been named in the charge sheet and yet they have been witnesses, my lord. Kindly see 133, my lords.
Dismissed.
Madam, I have already undergone 5 months. Investigation is over.
Cyber fraud, digital. Not only cyber.
Of course, it's a cyber fraud. Madam,
digital arrest.
We are the victims.
Digital arrest.
We are the victims. The complainant is made an accused. The complainant who lodged the FIR that I have been duped 30,000 rupees has been made an accused in this case.
Yes.
Lordship, you may kindly appreciate. Then I may be withdraw it.
Yes, better withdraw. Yes, dismissed as withdrawn. Yes.
Fresh matters completed.
Hmm?
Fresh matters completed.
Yes.
Item 23.
Yes. 23. Yes, Mr.
Allah appearing for the state, madam. High Court quashed the proceeding, madam.
306.
306, madam.
My letter friend informed me that there was some letter to the petition.
Lord, may I please, Lord, I'm appearing on behalf of the petitioner, Lord. Lord, the letter has been circulated in this matter, Lord.
There is no letter.
I think that they are not taken on record with it.
Due to some difficulties,
There is no letter. Where is the letter?
Lord, we have been served with the letter, Lord. On behalf of respondent number 4, Lord. On behalf of respondent number 4.
Who is respondent number 4?
I am on this.
You have served a letter,
No, AOR is circulated the letter.
but we have not received that circular letter.
I have
You circulated in between.
Well, maybe
Where are we?
circular is there, my lord, therefore maybe some technical issues are there.
So what is your difficulty?
Yes.
What is your difficulty?
Health issues. She is out of Delhi. AOR is out of Delhi.
As paid by Land Council for the respondent number 4, the matter is adjourned for 1 week. Post on 24th February. 24th.
Please, Lord, grateful.
Item 24.
Rajiv, item 24, I am for the respondent number 1, 3 to 7. Rajiv, may I request Lordship, last opportunity may be given to file my counter affidavit. The reason for non-filing is matter pertains to Punjab. My client was unable to procure the entire paperwork from High Court. Lordship, may give me the 10 days time, I'll file it.
It is already quashed.
Yes, it has been quashed.
This is an appeal from state against the quashing.
It is 324, 325.
But the charge was taken under section 307 also.
No, but conviction is under section 324, 325.
323. 324, 323. Page number 54.
To compromise you. For respondent, post the matter on. When do you want, Mr.?
Lordship, may give me 10 days time minimum because copy has not been procured yet.
On
Lordship, may have it in March then, if I may.
26th February.
Very well, Lordship. I am grateful.
Thank you.
Item 25.
May it please, Malaz. Malaz, this is an SLP against dismissal of my appeal against acquittal in limine, Malaz. Malaz, on the very first day, without Malaz the records and looking at the evidence, Malaz, the learned High Court, Malaz, dismissed my appeal. Malaz, I am the mother of the deceased, Malaz.
304B or 302 what?
302, Malaz. 302, 307, 386, Malaz, and Arms Act. The trial court record is not before my lords, Malaz. It hasn't reached as yet. But the...
I was about to ask that whether trial court record has been called.
No, Malaz. Apparently, the orders didn't show, Malaz, that the trial court record has been called.
So let us call for the report.
As my lord pleases.
What is the evidence according to you?
Malaz, the evidence is of Malaz last seen, the mother herself, and Malaz here the deceased died after Malaz about 16 days
of marriage.
Gunshot. It's a gunshot, Malaz, gunshot injury. He was first treated at Aligarh, then at Max in Delhi, and then when he recovered slightly, he went back but unfortunately the condition deteriorated and then he died, malas. So the deceased statement is also there, malas, which the court rejected, saying that it's a 161 statement and cannot be treated as a dying declaration. Malas, our own High Court, Supreme Court has, malas, decided this in favor that once a 161 statement is there and the
161 of the deceased.
Yes, malas. At that time he had survived, malas. At that
Died
time he
after
had
16
survived.
days.
Sorry, malas. Malas, after 14 days his statement is recorded, but he died a week thereafter.
Let record of the trial court be summoned.
Malas.
But in this case,
And digitized copy of the record be supplied to learned counsel for the parties, at their request.
Malas.
Post the matter on 4th May.
but this is a case where the eyewitness was withheld. Eyewitness was withheld. FIR after 11 hours. Died after 16 days. My lord, no.
You will get a chance to argue. Yes.
Right.
Obliged, malas.
Item 26.
Milords, this is coming up after notice, Milords, for the first time. There are several respondents who have not been served, and 5 have been served, out of which 1 has filed its wakalatnama, Milords. Mr. Rishi Maturia for respondent number 6.
Mr. Praveen Swaroop will be appearing for respondent number 1, 4 weeks to file counter affidavit.
Yes. Who appears for number 1?
Mr. Praveen Swaroop will be appearing. We haven't filed wakalatnama, we have to file counter affidavit.
For whom?
R1.
For 1 only. And for others?
R6, my lord, I am appearing. I have filed my wakalatnama.
R6. And what about others?
Others, my lord, some of them have not been served as per the office report, my lord.
Milords, 9, 10, 8, 2, as per office report, they have not been
Learned
served,
counsel
Milords.
appearing.
It says
Learned counsel appearing for respondent number 1 and respondent number 6 are allowed 3 weeks time to file counter affidavit. In the meanwhile, in the meanwhile, press notice be issued to respondent number 2,
And 8 to 10.
8, 9, and 10 for service through the concerned SHO. Post the matter on 19th May.
Instead of 3, can I be granted 4 weeks?
4 weeks already.
Okay.
deeply obliged.
Item 27.
Lordships, I appear for the state. Lordships, we have received trial court records Sunday night. Lordships, may kindly keep it after 1 week. We'll peruse the records and we'll argue it finally.
What is the matter? Bail matter or what?
No, Your Lordships, criminal appeals will do.
Challenging a conviction under section 302.
302.
I will request for at least 3 weeks.
I will request for 3 weeks because the record has received on Saturday. I will request at the request of both the parties, post the matter after 4 weeks. Date down now. Post the matter on 22nd April.
Item 28.
इसलिए मना किया हूँ चेकिंग तो होनी चाहिए मना इसमें पासपोर्ट में नहीं मना किया.
Sir, legal aid matter, the petitioner has undergone somewhere around 6.5 years under incarceration, Milords. The primary argument that I am taking, Milords, with due permission today is that the age of the prosecutrix has not been proven as per the POCSO Act matter. Now, argument number 1 qua this premise is that first of all,
Section 94 prescribes the determination of age provision, my lords. Now, as per Section 94 of the JJ Act, certain prerequisites were required to be fulfilled. Those were not fulfilled. Rather, what has happened, my lords, is prosecution has relied upon a baptismal certificate, my lords. A baptismal certificate which is one issued by a church minister who is not examined as a witness. Two, my lords, basically IU has also stated in their cross-examination as well as chief that yes, they made no attempts whatsoever to prove the age of the prosecutrix. Now that has been very well appreciated by the Honorable High Court in its judgment at para 11, my lords. That one, no independent medical assessment was being done to determine the age of the victim. And two, my lords, that this baptismal certificate per se cannot be looked into. That is my proposition, my lords. That is first bit. Second, my lords, what has been taken on record to determine the age of the prosecutrix here? Pertinently, this baptismal certificate is not exhibited, my lords. It's marked as paper mark 1 in the trial court record, my lords, as being received by us. My lords, apart from that, no charge under section 376. If I were to assume that she is a major by all sorts, my lords, no charge under section 376 has been framed by the learned trial court, basis which conviction otherwise would have taken place under the Indian Penal Code.
You want a separate charge under 376?
No, my lords.
If POCSO fails and age fails, they cannot be convicted under 376. That is your proposition.
My lords, I am relying upon a judgment.
Whatever relying, first proposition and thereafter reliance.
Please, my lords.
Have I understood properly your proposition? In the case of POCSO, if the prosecution fails to establish the age of the prosecutrix, then the accused has to be acquitted and he cannot be convicted under 376. That is your proposition. Yes, please. Yes, please.
My lords,
you are citing some judgment. Interesting. Let us see if there is any such judgment.
my lords, the judgment otherwise is Gyanendra Singh alias Raja Singh versus State of UP, my lord.
We have said so.
My lords, the interplay of section 42 and 42A has been explained in this judgment.
No, we have said so that separate charge under 376 is required.
Unfortunately, that has not been directly
Which
stated.
paragraph?
But my lords, I'll take my lords to this judgment for this a little bit, my lords. My lords, in this matter, what had happened was
In this judgment?
charge.
In this one?
Please, my lords.
Yes.
In this precedent, my lords, para 9, my lords. I draw your attention to para 9, my lords. May I be permitted to read the paragraph?
Yes.
Because in this, investigation was concluded and the charge sheet was filed against the appellant in the trial court for the offences punishable under section 376(2)(f) and 376(2)(ii) of IPC and section 345 of the POCSO Act. The trial court framed charges against the appellant for the said offences who pleaded not guilty and claimed trial. My lords, that is one. Now the charges were framed under both POCSO as well as IPC, my lords. My lords, what was the contention which was being raised in this particular matter by the appellant is mentioned at para number 12. Para number 12, my lords. Shri such and such appearing for the appellant advanced a solitary submission urging that the trial court ought not to have convicted the appellant for the offences punishable under section 376(2)(f) and 2(ii) of IPC because the acts alleged are defined as offences in both category of laws. That is the general laws. That is the IPC as well as the special law, that is the POCSO Act. Since the offences are overlapping, the special law will prevail over the general law. And hence conviction of the appellant could not have been recorded by the trial court for both the offences. Now, this is the contention which was being placed on record by the appellant. To that, my lords, the court, honorable court has held at para number 17. The only moot question which thus requires adjudication is whether conviction of the appellant ought to have been recorded under IPC or whether the special law. Section 42A of the POCSO would prevail thereby, vitiating the sentence awarded to the appellant for the offences punishable under section 376(2)(f) and 2(i). 18, my lords. Then section 42A has been quoted. Thereupon at para 19 it says, A bare perusal of 42 of POCSO Act would make it clear that when alleged acts or omissions constitutes offences, my lords, constitutes meaning thereby essentials are fulfilled, both under IPC and POCSO Act, then the law which prescribes...
Where is the charge framed against you?
Below page number... My lords, page number 127, annexure P14. May I read the charge, my lords? Section 3, 4 of POCSO and
Yes.
6 of IPC.
Yes.
Firstly, on 26/11/19, you committed such and such, act such and such, thereby committed the offence of under section 3A of POCSO Act, punishable under 4 of POCSO Act, within the cognizance of this. Secondly, that on the said date, while committing rape on the victim, you threatened to strangulate her, throw her in the coal pit, which is situated near the place of occurrence, thereby committed the offence under section 506, within the cognizance of this. My lords, I most humbly submit that the precedent that I have put on record, what I want to argue and assist this honorable court with respect to the proposition that I have just made is that, my lords, in this matter, in Gyanendra Singh precedent, my lords, in that case, both the charges were framed under the IPC and the POCSO.
Yes.
Supreme Court has stated thereupon that when the charges under both the provisions are framed, that you have been found guilty under both the offences, only then the greater punishment will come into play, which is section 42. Because that is my primary argument.
Yes, yes.
This is the aspect I wanted, my lords.
Yes, yes.
My lords, as otherwise, or upon...
This is not a proposition for your argument
My lords,
that in the absence of any charge under 376, and if the charge is only under POCSO, and if the prosecutrix is found to be not less than 16 or 18 years of age, then you have to be acquitted.
my lords require a judgment to that effect.
Yes. Because this is Gyanendra is not a proposition for that.
Please, my lords, I'll pull out a judgment and assist
On that.
on
Yes.
the proposition.
Yes.
I'll do that. I'll do that.
Yes.
Because, my lords, otherwise, I'm so sorry, I'm just pushing, my lords. But what I want...
No, no, you argue your own way.
Judgment was basically this, that in this judgment, my case, this item 28 is on a higher pedestal as opposed to Gyanendra Singh. In this matter, both the offences, under both the laws were charged. And then Honorable Supreme Court has stated that higher of the two will come into play. Applying section 42, I am giving you punishment under POCSO or 376. I can understand, my lords, the intent of the legislation was to punish the persons who were committing such heinous acts upon the minors, my lords. But here my point is only solitary, that if I am not a minor, then what will happen to my case? If I have not proven that I am a minor, I understand there is a reverse burden of proof, my lords. But the age is supposed to be proven by the prosecution in order to invoke POCSO. That is all, my lords. I'll pull out the judgment and file it to us.
First you read the judgment, because the High Court has found that the victim was less than 16 years of age.
Milords, may I just
Yes, you read out and convince us that the finding is not correct.
Please, Milords. Para 11 and Para 12. Milords, what is the basis of the High Court, the Honorable High Court stating that that the prosecutrix is a minor? They are relying upon the testimony of the mother and the prosecutrix. Is that permissible as per section 94, my lords? I would argue no. Apart from that, my lords, second aspect what they have
94 is about a juvenile.
My lords,
94 is not for proof of age of a victim.
My lords, I understand. My lords, I follow.
You understand?
My lords, but can I? My lords,
94 is not a proof for age of a victim, but it is proof of age of a juvenile accused.
my lords, otherwise,
For proof of age of a victim of rape, the standards are different.
my lords, I follow. Otherwise, Jarnail's judgment is there to that effect. Otherwise, also, my lords, the definition of juvenile under the JJ Act prescribes that that the definition of the child is also defined under the Act. in that very act that whosoever is below the age of 18, below 18 years of age, that person is supposedly a juvenile or a child under the act. But my lords, I follow what my lords is seeking here. Otherwise, I was rooting for Jarnail Singh's precedent in this matter, because I'll bring that also to satisfy on this count. Because otherwise, the second aspect which the Honorable High Court has relied upon in order to say that the prosecutrix is minor is that they are relying upon the MLC of the victim, which is placed on record by the Dr. PW9. But I would like to submit here that he has not made any independent medical assessment, which is what the Honorable High Court has also stated and recorded in para 11. And even during the cross-examination of PW9, he admits that he has not made any medical assessment to determine the age. If that is so, then how come is he recording that she has attained menarche or not? This is the basis why Honorable High Court is stating that, holding that prosecutrix is a minor.
Yes.
Also, you'll find at page 139, at 138, the PW2 has produced the certificate figure. At paragraph 17 at page 139.
Yes, take out these two judgments, AIR 81 Supreme Court 361 and AIR 2003 Supreme Court 630.
And the Lordship has relied on baptism certificate in one of the judgments, my Lord, 2002 9 SSC 144.
Trial court has referred to these two judgments.
Page 236, my Lord.
Yes. Trial court has referred it,
Yes, to your
and they seem to be on different point.
Your Lordship on say different issue, but your Lordship will see this.
Some certificate was found to be valid
Yes, my lord.
and reliable, but not for age.
Yes, my lord. If your Lordship will
In
see.
2003 Supreme Court,
Yes, my lord.
page 236,
Yes, my lord.
High Court has, trial court has quoted the paragraph.
Yes, my lord. These two paragraphs.
It has been held that regarding proof about legitimacy of child,
Yes, my lord.
that the birth certificate proceeding on the basis of baptism certificate containing fact that baptism record was read and checked before the godparents
Yes, my lord.
and signed by person along with godparents, such certificate is valid.
Yes, my lord.
It is about the validity of the certificate.
Yes, my lord. That is the issue.
You are drawing parallel that if the certificate is valid for one purpose,
yes,
it should be valid for another purpose also.
Yes, my lord. Because the issue which falls for a Lordship's consideration is whether the victim was minor on the date of incident or not. For that aspect, my lord, three things have been considered by the trial.
We have to consider only that aspect.
Yes, my lord. So now,
if we find
yes,
that there is proof of age, then the matter ends.
Yes, my lord.
If there is no proof
yes, my lord.
of age,
yes, my lord.
then we may go to the other argument.
Yes, my lord.
That in the absence of charge under 376,
whether he can
there is no conviction under section 4, no conviction under section 376 also.
Yes,
that is the second part of the argument.
Second aspect of the matter.
So only two arguments are there.
Yes, two arguments. So far as age is concerned, my lord, if your lordship will see this testimony of the witness which has been produced and not questioned, my lord, at page 138. Page 138 is the PW2 state, PW2 who was produced for the doing the baptism certificate, my lord.
Here the child was, the victim was not sent for medical examination. Ossification test was not done.
Yes, ossification test.
Only baptism certificate is the evidence before the court.
And then in the report
and mother's statement.
Yeah, and then the report of the doctor also, your lordship will see. If your lordship will kindly see the MLC 96, my lord. Oh, sorry, the doctor's evidence is
MLC starts from 43.
Yes. At 55, your lordship will see one line at the middle of the age is indicated in the doctor's side. Page 55. Onset of so and so. If your lordship page 55, middle of the page, my lord, of doctor's certificate. It says no onset of menarche in case of brother. So
you see, doctor's certificate about age is different.
Yes,
then doctor's certificate about the
yes,
finding in respect of
yes, my lord. Because
proof of
yes, my lord. There are three things which I support the case of prosecution. One is, my lord, that the so far as the age is concerned, it was never disputed, which has been recorded by the trial court. All that is one. Second, my lord, that baptism certificate was produced by the PW2, indicating the age. There is no cross-examination on this aspect. My lord, that the minor is not victim. Sorry, the victim is not. Third is, my lord, that in the overall medical examination of the victim, my lord, it also appears that the victim was minor. My lord, these are the three factors which have weighed with the trial court and high court and at no stage, my lord, the accused has disputed the age that the girl is or the victim is not minor. These are
it is argued before the court.
If your lordship,
High Court has
only not in the exam.
In fact, High Court has also there is no categorical finding by the High Court.
Yes, my lord.
High Court has sometimes assumed that even if she is not a minor, then 376, and then again goes back to baptism certificate.
If you lordship,
every other paragraph by the High Court is not in consistency.
Yes, but there are some. If your lordship will see 230 trial court judgment at 236, your lordship has noted.
Like a judgment, no?
Okay. And paragraph 43, if your lordship will see, after citing those judgments, 43 at page 6 bottom. As such, contention as raised by the Learned Defense Counsel is not tenable. As per paper mark 1, the date of birth of the prosecutrix is 5/3/2006, which was entered in the register of church of so and so during baptism of child. Thus, it is evident that at the time of occurrence she was 13 years old. So that certificate, which was never questioned, my lord, And in paragraph 39, my lord, where after the argument of learned defense counsel at paragraph 38 at page 235, learned defense counsel has tried to put paper mark 1 under the cloud of suspicion on the aspect like the investigating officer found out that age of victim based on the baptism certificate issued by so and so church came to the conclusion that victim is 13 years of age, and whereas the statement of church minister has never been recorded by investigating officer. During the trial, PW2 mentioned the victim was born on 5/3/2006 and exhibited the baptism certificate at paper mark 1, which was the same compared with the original and found to be true and correct, and the same was signed by the church minister. Dr. PW9, who has medically examined victim, also mentioned the medical report.
This you are reading at page?
Page 235, paragraph 39.
39.
Yes, ma'am. During the trial, bottom of the page, PW2 mentioned that the victim was born on 5th March 2006 and exhibited the baptismal certificate at paper mark 1, which was same was compared with the original and found to be true and correct, and same was signed by church minister. Dr. PW9, who medically examined the victim, also mentioned in the medical report exhibit PW the age of victim as 13 years, and in cross-examination categorically stated that blood stain in vagina so and so, since the victim has not attained so. So these are the two materials, two factors, my lord. One baptism certificate, one. And 40, my lord, now defense never objected to paper mark 1 when PW2 was exhibited before the court, and said document is a public document and is admissible under section 35 of Evidence Act. Examination of the person making such entry is not necessary. So the trial court, in my humble submission, have considered this aspect. And at the earliest stage, my lord, they could have raised the objection as regard to the age of the victim, my lord. They did not. In the examination of the PW2 also, PW9 also. And if Lordship will see the testimony of the minor victim, my lord.
Where is that baptism certificate?
It is at page 96, my lord. Page 96. And except P7. And
who has proved this?
Yeah, this was by PW2, my lord. Mother, my lord. Mother, my lord, at page 138. The lordship will have. And page 138, my lord, page 138 at 139, paragraph 17. Paragraph 17, your lordship. This minor victim daughter was born on 5th March 2006. Paper mark 1 is baptismal certificate of minor victim daughter. Paper mark is compared with the original and found to be true and correct. And in cross-examination, lordship will find no objection, nothing, even not suggestion.
You have not challenged that.
It's the certificate.
Not neither the certificate nor put any question to the mother that her date of birth is not this which you are stating or which is recorded in the baptism certificate, but it is something different. And by that, your daughter is not minor, she is major. You are not telling the correct facts to the court. There is no suggestion, not even a single word.
Milods, apart from that, I just submit Milods.
Accused knew that she was minor.
The certificate does not bear the signatures of the mother, first of all.
Which
Second of
certificate?
all, the baptismal certificate itself does not bear the signature of the mother.
It is issued by the church, not by the mother.
That is what, Milods. Could she produce this document? No. Second,
no, why?
And if we look at the testimony of the mother PW2, all the other exhibits have been marked as exhibit P 1, 2, 3, 4, 5, 6, 7. This particular exhibit is not marked only. It's been marked as paper mark. So that is one aspect. Although I understand, Milods, that particular question has not been asked to this particular witness, but then the question on the other hand has been asked from PW9, who is the doctor who has made such remarks about the minority and majority of the victim, with respect to the age of the related observation made under his MLC. Apart from that also, Milods, regarding the onset of menarche or not, since apparently vaginal swabs are bearing blood stains. Milods, when the prosecutrix herself has informed the doctor PW9 that she has not attained menarche, of course, he would presume that these blood stains are not of the menstruation and otherwise. So that is the other argument that I wanted to place. Although, my lords, I follow that we have not asked specific questions to these witnesses, but we have most definitely argued before the trial court as well as before the Honorable High Court and contested their age, which has been considered. And apart from that also, my lords, the Honorable High Court has particularly stated that regarding the medical assessment and the proof of age, they are also on the same page as us that yes, no independent medical assessment has been done. They are only relying upon the statement of the prosecutrix, the mother, and then the finding of the so-called finding of the doctor.
Yes, heard and counsel for the party is reserved for judgment. दोनों लिखना था, judgment of the order. Yes.
Millards, the judgment that we were making.
You wish to file any written submission?
We can file.
We can do that.
Learned counsel for the parties leave for some time to file written submission.
So 4 pages. 4 pages.
Written submission, not more than 4 pages, along with citations and its copies.
These kinds of cases, my lords, we are getting the very limited instructions. These kinds of matter, we are getting a very limited instructions. We could not contact the clients, and sometimes we are preparing the file itself.
Legal advice.
Legal advice, my lords. That's the reason.
We know the difficulty.
That is sometimes we cannot go on the details.
You can you file the copies, or you will mention citation only?
We will file the copy.
We'll file the
Copies also. There is no difficulty for that.
Good.
Yes. 1 week.
Take your
Item 29.
Lords, I appear for this.
Yes.
Again, legal aid matter was coming up after notice.
Mhm.
Initial matters, there were 4 accused matters. These accused were charged matters under section 498A 302 read with 34. This is a trial court matters convicts. The accused number 1 and 2 matters. One is the husband matters, husband of deceased, and mother of petitioner for matters under section 498 and 306 matters. The specific charge was not framed under 306, but conviction under 306 matters, and sentenced for 7 years. And 3 and 4 matters, whose 3 is the sister of the petitioner, and 4 is the brother-in-law. Under 498 and sentenced 2 years. On appeal matters, the High Court acquits matters 3 and 4 from all the charges and convicts matters A1 and A2, petitioner under section 498 and 306, and matters A2, mother-in-law of a deceased.
How much you have suffered?
4 years matters, almost 6 months matters. 4 years, 5 months now.
4 years, 5 months.
Lodge, please.
And totally 7 years.
7 years.
Yes.
My lords, if I may submit. So basically
he is not pressing on merits.
If you kindly see the medical evidence, there is no proof. There is no evidence that
you have already suffered now.
That's it.
My lords, it's a
We'll reduce it to the period under
fairly reasoned order. The trial court's order is fairly
No, already. Yes, it is reasoned order.
Yes.
Ours also will be reasoned order.
I'll leave it to my lords.
Already suffered 4 years, 5 months, and probably with remission, he must have suffered by 6 years by now. 6 or 6.5. Only for a few months reprieve for him. It's a legal matter. Legal matter. Though we can't mention, but
I would like to
legal aid concession is also there.
But I would like to submit that there is evidence with respect to this.
No, we are maintaining the conviction.
There are corroborative evidence as well with respect to prosecution witnesses. They have said they were.
We are not acquitting him. We are not acquitting him.
I would like to pose it because it's a social evil in this society, and I personally,
therefore, we are maintaining the conviction. Since it's a social evil, we are maintaining the conviction. We are not acquitting him.
Or it's just 2 years more. He should be in.
For you, it's 2 years more. For him, it is 2 long years.
I leave it to my lords.
4.5, not 2 years.
4.5 years. If you are condition,
2.5 years.
2.5 years.
What is the date of incarceration?
But if you are 112 months, page 112 is the custody certificate.
In jail since?
From first malus from 18/6/2017 to 13/10/2018.
18/6/2000.
18/6/2007 to 13/10/2018. Then again malus from 2012/2022 till
2012/2022
till date.
Till date.
Last place. But if you kindly see page 112.
You calculate?
It's a 4 years, 5 months malus.
4 years, 5 months.
Custody, when I filed malus on 12/2/2025, it was 3 years, 5 months, 18 days. Then 1 more year malus now. 112, page 112 minutes. I get the custody certificate.
Take. Leave granted. The appellant stands convicted by the trial court as also by the convicted concurrently by the trial court as also by the High Court for he is the husband for committing offense under section 498A of the 34, read with section 34.
And 306.
Just a minute. So what is this in para 1 of the High Court order?
And 306 Malas. The High Court records the trial court Malas.
No. In the first offence, for the offence under section 498A/34, appellant Sarbani Sardar and Anand Sedar.
Yes. There are 3 and 4 Malas.
And they have been acquitted. Viswajit Mandal is second part.
Yes, yes.
498A read with section 34 IPC and under section 306 read with section 34 IPC and has been sentenced to undergo RI for 2 years with fine of ₹2,000 and RI for 7 years with fine of ₹5,000 respectively for each of the offences. Full stop. Petitioner's wife, Amrita Hajra, died committed suicide on 18/6/2017. Full stop. Although initially charged under section 302 IPC was also framed, but subsequently the trial court found the appellant and other persons guilty of committing offence under section 306 IPC.
A1 and 2 only Malas, not 3 and 4. And A1 and 2 only.
A1, A2.
Not other. 3 and 4 are.
Found accused number 1 and accused number 2 for committing offence under section so and so. Full stop. Para. We have perused the. Upon hearing learning counsel for the parties at length and on perusal of the judgment rendered by the trial court and the High Court as well, together with the evidence adduced by the prosecution, we are satisfied that there is abundance of evidence against the appellant which would amount to commission of abatement to commit suicide, as by their act of torture the deceased was driven to commit suicide. Full stop. Thus, we are not inclined to interfere with the conviction on merits. Full stop. Para. At the same time, comma, it is to be seen that the petitioner is under incarceration, was under incarceration from 18th June 2017 to 13th October 2018, and thereafter since 22nd December 2022, 20th December 2022 till date, and has thus already suffered jail sentence of about 4 years and 5 months. Full stop. The total jail sentence awarded to the appellant is RI for 7 years. Full stop. Thus, with remission, with remission, he would have completed more than 5 years of incarceration. Full stop. Considering the entire fact situation of the case, we are inclined to reduce the sentence to the period already undergone. Full stop. Accordingly, we direct that if the petitioner is not required in any other offence, comma, he may be released from jail. Full stop. The appeal is allowed in part.
Obliged.
Dr. Nirmal Chopra is online. He's
Yes, Dr. Chopra.
Just got cold and cough last night. Very bad cold and cough. Here also, I have no objection. I am adopting the arguments which my learned friend she has already made in the
You know, Dr. Chopra is suffering from cold and cough. लिखना नहीं है ना वो
maybe necessary or may not be necessary.
उनका appearance खाली लिखना है.
Yes, I'm very much obliged. Very.
Please mention item 31 from today's list, my lords. Just seek further time to file counter and for the state. Other states being informed.
31. Next one. Next after next.
Yes, my lords.
31.
Another
4 weeks counter. Yes.
Obliged, my lords.
Yes.
May I please, my lord? And this comes after notice.
Yes.
Original record is received, my lord. We have received by email.
Original record is?
Original record is received already. We have also received by email.
Uh-huh.
If I can tender the brief note, my lord, if I can.
Yes.
And this is a case of 302 conviction, my lords, read with atrocities act.
PW1 is mother of deceased.
Mother of deceased, my lord.
She is injured eyewitness.
Not really, my lord. In fact, the occurrence could not be also proved by her own testimony, if I will go through that. My lords, may I have my note, please?
Yes.
My lord, this is the place, Ogipur village, Tandur Mandal, Vikrabad district in Telangana.
Mm-hmm.
It is alleged on 12th May 2013, the incident happened at the house of petitioner. The deceased was found dead. It is also being alleged that I had hit the deceased with Shabat stones, which is a limestone used for flooring. And that's how the prosecution case is set up.
What is that stone? What stone?
Shabat stone, man. It is a local Karnataka-based stone, man. In that belt it is found. It is basically limestone.
Mm-hmm. Yes.
My lord, I am charged under 302 on 4th, over the page, my lord, 4th February 2014. I am charged under 302, 324, then Atrocities Act 31X and 32B.
Yes.
They have examined about 11 witnesses and there are about 16 exhibits. And I am convicted by trial court for life imprisonment for 302, my lord. And also for Atrocities Act, life imprisonment followed along with respective fine I have mentioned, my lord.
Yes.
And my lords, on page 3, I have given my period of custody before I begin with the deposition. During trial, I was remanded for about 3 months, 3 days. Post conviction, I have spent 5 years, 2 months, 24 days, and I have surrendered before coming to your Lordship's court on 28 2025. And since then, I am confined. Lordships may have depositions PW1. In this note, I have reproduced the deposition in cross. PW1, as per prosecution, states that PW3, who was eyewitness, the friend of deceased, who accompanied deceased to the place where incident has occurred, returned to her. They both left from home together, and then PW3 returned to her to inform that deceased is being assaulted by the petitioner. In the cross, she says, PW3 has never come to my house. And also she says there was no panchayat held. The essence of panchayat is about the motive assigned to kill the deceased. Lordships may have this. What they have done is, the motive which is given in the present crime is that because it is alleged that sister of the petitioner had eloped with deceased, so that becomes my motive to kill him, and for which purpose there was a panchayat convened, and in the panchayat the deceased was banished from the village. That is the prosecution's case. This is not supported by the mother, not supported by the people who convened the panchayat, and there is no other evidence as such.
Yes.
Lordships may then have PW2 is uncle of deceased, who gives the departure details of the deceased early in the morning. Again, there is no circumstantial evidence leading to the implication of the petitioner. PW3 is the very same.
PW1 is father.
Is mother.
Mother.
My lord, PW3 is that person who accompanied deceased from house to petitioner's house, from his own house, from deceased's house, sorry. And he then turns hostile and he says, I never accompanied the deceased to the house of petitioner. In fact, he gives another story that they went to some hotel, and I will go through that deposition minutes. It is in the criminal appeal original record received by your lordships at page 16 of the High Court's paper book. My lords may have it.
That means PW1 is not an eyewitness.
PW is an eyewitness. No, she can't be an eyewitness because she says I was called by PW3. PW3 says I've never gone to her. She herself says he has never visited me.
No, in the examination in chief, she has supported the prosecution or
She has supported. In the cross, she contradicts. Totally.
in the cross, she says son died due to falling down and receiving injuries, and accused is not concerned to this.
But it is a suggestion, my lords. It is a suggestion. It is not true to suggest that my son died due to falling down. Because before that, she has admitted that LW6, who is PW3, never came to her house. The place of offense is main road. There are no independent witnesses. It is all between deceased petitioner, PW1 and PW3. PW3 is hostile. I am implicated. There is a deceased person. Mother does not support the prosecution's case and contradicts rather.
Mother has supported the prosecution case then.
My lord, she has contradicted the PW3 says I never went. She also admits he never came to my house.
I don't want to interject my lord.
PW3 might not have come to his house, but independent of that, she has seen the occurrence.
She has not seen, my lord. That is her story. That my son and PW3 left. After 5 minutes, PW3 returned and informed that petitioner is assaulting my son. And that's how she came to know, and she then rushes to the spot. So entire story is revolving around that.
PW3 is hostile.
Is hostile completely. My lord, that's why my lords may turn to the depositions paper book sent by High Court.
Because you have only extracted the relevant.
Yes.
Favorable to you.
Yes, my lord. My lords may have the deposition. My lords have received the original record from High Court. I'll read the very same record, my lords. It's a paper book.
At least for PW1, my lords can see the paper book at page 32. If my learned and because that's the same.
Because we will have all the depositions in that.
So just for convenience of my lords, till the time the record is being given, at page 32, my lords, of the paper book, PW1 at least is there. PW2 is not there, then PW3 is there.
In that paper book, my lords, page 10 is PW1, Mala Padmama.
ये उल्टा लग गया है. Yes. Padmanamma.
Yes, ma'am. May I read, my lords?
Yes.
I am resident of Ogipur. I belong to Mala caste. LW2 Naresh is my son. LW3 Venkataiah, LW4 Maruti are my brothers. Deceased Shivakumar is my elder son. I know the accused and he is resident of Ogipur. 3 years ago, deceased came to my house in the early morning from Ikmai village at about 8 a.m. Deceased along with Narendra, LW6, he is the PW3 man, left the house stating that they are going to their friend's marriage. Within 5 minutes, LW6 Narendra returned to me and informed me that accused was beating the deceased on the road. On that, myself and Narendra rushed to that place and found that the accused was beating my son with stones. He also beat him on the chest of the deceased. When I went across, the accused also beat on my left side face below the eye. He abused me as Mala Lanja, Mala Munda, Madiga Munda. Deceased received injury on his chest and his teeth are broken. Thereafter, accused left away. I informed the matter to my brother LW3 Venkataiah and LW4 Maruti on phone, and then I shifted the injured to government hospital. After giving first aid, they advised me to shift the injured to Osmania General Hospital. When I was at Tandoor Hospital, LW3 Venkataya and LW4 Maruti came there. Again, I narrated the incident to my brothers. Myself and Maruti shifted the injured to Osmania Hospital in the ambulance. On the way to OGH and near Vikrabad, the injured passed away. As such, we took the dead body to Tandoor Government Hospital. About 3 months prior to this incident, my son took away the sister of the accused. On the next morning, he brought back her. A panchayat was held in the village and the girl was sent to her parents' house. Because of that reason, the accused caused the above incident. The SI of police LW6 Pawan came to the hospital, Tandoor. I orally complained him about the incident and he recorded my statement. My statement was recorded by him and the same was read over to me. I affixed my thumb impression on the statement. DSP examined me and recorded my statement. And then the cross mining. LW16 Pawan, SIP examined. After the return to Tandoor Hospital with dead body and prior to that, he did not examine me. It is not true to suggest that I do not know the contents of Exhibit P1. It is true that in connection with eloping of girl by my son, there was no panchayat held. My lord, this is very important because this assigns the motive at later stage maybe, but she says there is no panchayat held. It is true that LW6 Narendra never came to my house. The place of offense is a main road. There were several people where my son fell down. Nobody has been examined. It is not true to suggest that my son died due to falling down and receiving injuries and accused is not concerned to the same. It is not true to suggest that deceased did not go along with Narendra on that day of incident. Now she further contradicts the aforesaid statement. My lords may have PW3.
PW1 suffered eye injury.
My lord, that I have that exhibit P15. The doctor is not examined. Time of the incident is not mentioned. Nobody is examined on that. PW3 is at page 16, my lord, same volume.
Yes.
He happens to be the alleged eyewitness. May I read my notes? I am native of Antharam. I know deceased Shiv Shankar, resident of Ogipur. I know PW1, mother of deceased. I know accused Talari Naresh, resident of Ogipur. 3 years ago, in the morning hours at around 7 a.m., Shiv Shankar came to my house and woke me up when I was in the house of my maternal grandmother at Ogipur. I freshed up and then we had a tiffin in the hotel. He requested me to drop at Chhatrishala. I agreed to take him to Chhatrishala. For 10 to 15 minutes, we were there at the hotel. When I started the two-wheeler, the accused came there. He spoke to me and Shiv Shankar. When I asked the deceased, where is he going? He replied that he is going to the village and asked me to go away. Then I returned to my house at Ogipur. I did not go to the house of PW1. DSP examined me. One of the entire prosecution story suffers here. He does not go even on the first instance or on the second instance. Mother admits that he never came. That is the whole prosecution story.
This is Maruti.
No, my lord, this is Narendra. The LW6 Narendra, who is examined as PW3. And in the cross-examination by the APP, because now he has turned hostile, it is not true to suggest that I stated before the police that accused pulled the deceased and later the accused asked me to go away as I am not concerned. And then I left to Irugapalli village as in Exhibit P2 161 CRPC. I deposed falsely at the... He denies all suggestions put to him. But that's how the entire story of prosecution suffers. He is the alleged eyewitness who informs the PW1. PW1 also admits he never came. And my lords may have
hostile.
Yes, he has been declared hostile. My lords have page 17 top. As witness rescinded to support prosecution case, learned APP is permitted to cross-examine witness.
Yes.
My lords may now turn to the doctor's evidence. Before that, my lords may have PW5, Narasimha Reddy. My lord, these two witnesses are examined to show that there was a panchayat held. The only purpose for examination of these two persons is to prove the motive. Now they have also turned hostile. This is PW5. PW4 also, sorry my lord. Before that, PW4, page 18. Name Tamanna. Chief is
also hostile.
Both are hostile. The essence is, my lord, the document is very much there. she has turned, both of them have turned hostile to say there was no panchayat. There is no such story that the girl, the sister of petitioner eloped. There is no such motive which could be assigned, is my submission. Then my lords may have PW7, the doctor. Postmortem doctor, my lords. It is not that wound certificate doctor. May I read one?
Yes.
I am page 24, PW7. I am working as clinical operations manager at American Oncology, Serilingapalli, Hyderabad. Previously, I worked as CAS Tandoor from 11/10/2012 to 31/12/2013. On 13th May 2015 at 2:30, it should be 2013 minutes. At 2:30 p.m., I received requisition from SDPO Tandoor for conducting PME on the dead body of Malla Shivshankar. Body was identified by PC of Karankote police station. On the same day at 2:45 p.m., I commenced autopsy on the dead body of the deceased and concluded at 4 p.m. I found following external antemortem injuries. Now, my lords, these injuries are contusion, left black eye present, laceration, contusion, all lacerations and contusions. On opening the body, on page 25 minutes, middle of the page, on opening the body, I found following internal injuries. Intracranial hemorrhage is noticed in pontine and temporal regions. The reason of death is massive intracranial hemorrhage secondary to head injury leading to cardiorespiratory arrest. The time of death is 12 to 24 hours prior to commencement of PME. I issued exhibit P8 PME and it bears my signature. My lord, now this becomes important. By mistake, I mentioned the date as 14/5/2013. But this mistake is at 4 places. He mentions the date of requisition as 14/5. At all 4 places, he writes at 14/5 only. And the reason he gives is due to night duties, as it is 24 hours duty. Moreover, in the cross, my lords, what he explains in cross, as nobody asked me, I did not inform before that to the police that by mistake I have mentioned the date 14/5/2013. This is the doctor who is deposing after 4 years and who is now holding some other charge, and he remembers that I was on 24 hours duty. I have committed a mistake, which has been there for at 4 locations in the very same exhibit. And he is further given a suggestion to which he agrees. It is true that above mentioned injuries are possible due to an accident. My lords may mark it.
Yes.
Now, my lords may have the investigating officer at PW, who is PW10 at page 31. PW7 is the officer, my lord, who recorded the statement of PW8 is the officer who recorded the statement of PW1, and PW9 is Tehsildar who is brought on record to prove the caste certificates. My lords may have page PW10 as page 31. I am working as DSP. My lord, this is investigated by a DSP rank officer. Previously, I worked as SDPO Tandoor from so and so period. I received appointment orders to investigate the case. Then I received CD file from PW8 Pawan and verified the statement of complainant and FIR. On 13/5/2013, I visited scene of offence, village Ogipur. I secured 2 mediators and conducted scene of offence, Panchnama Exhibit P5, and recovered stone MO1 under cover of Panchnama and obtained signatures of Panch. Thereafter, I visited government hospital mortuary room over the dead body of the deceased in the presence of same mediators, and during inquest, I found 8 injuries on the face and all over the body of deceased, and the same were noted in the inquest and seized blood-stained clothes of the deceased. At the time of inquest, I examined and recorded the statements of PW1 and 2, LW2, LW3 and LW5. Then I gave a requisition to the medical officer to conduct post-mortem examination on the deceased Malla Shivshankar. MO3 is terry cotton full sleeve shirts with black and white color strips. MO4 is blood-stained underwear. Then I affixed punch chits on MO1 to 4. On 14/5/2013, I filed a requisition before Tehsildar for issuing caste certificates. I have deposited seized case properties in the court along with the letter of advice with a requisition to be forwarded to APFSL. On 15/5/2013, the accused was apprehended and produced before me by PW8. I secured 2 mediators and interrogated the accused in their presence and recorded the confessional statement of the accused and obtained the signatures of Punch. On 28/5, I received the caste certificates and deceased Shiv Shankar belonged to SC Malla community and accused belongs to Mudiraj of BC community. These are now, my lords, the exhibit he collects. My lords may have the cross-examination. I have not collected first aid treatment particulars of deceased at Government Hospital Tandoor. PW8 has recorded the statement of PW1 on 12/5/2013, only which is exhibit P1. It is true as per FIR, the information was received at 2 p.m. to the police station. As per exhibit P15, my lord, this is very boon certificate of the PW1. There is no mention that PW1 was referred to any government hospital. It is true that exhibit P15, the time of examination, PW1 was not mentioned. This is very vital. As per our investigation, the scene of offence place is main road and there are several shops and quarries are situated by the side of main road. It is true that I have not examined any adjacent shop owners of the scene of the offence. It is true, it is not mentioned in CD that the scene of offence place was kept intact. Since, my lord, the murder weapon according to the prosecution is Shabazz stone, they do not even secure the crime scene. He admits, the investigating officer. It is not true to suggest that I have conducted table investigation without visiting the scene of offence and not conducted inquest Panchnama and not seized MO 1 to 4 in presence of mediators. It is not true to suggest that PW 3 to 5 have not stated before me. It is not true to suggest that accused did not confess anything in presence of mediators. It is not true to suggest that accused was falsely implicated. Now that's how, my lords, the evidence is. PW1 does not support. PW3 is hostile. 4 and 5 are hostile. Occurrence itself is not proved. P15.
Do you say PW1 has not supported?
My lord, PW1 says, in the light of PW3 being hostile, she also says he did not come to me. So she does not explain who informed her about the beating, alleged beating, which she says in the chief examination. That I was informed by.
He is not responsible if PW3 turns hostile.
My lord, that's why. Then not only that, she also destroys this theory of panchayat.
If someone is hostile, why should the eyewitness be?
My lord, she admits that he never came to my house. At one point, she says that it is LW6, PW3 who returns in 5 minutes to say that my son is being beaten up. Then I proceed.
Yes.
And then she says he never came. And that's how he also corroborates PW3. I never visited. This is not so common, my lords, that she will come on her own. Her precise case is within 5 minutes he returned, informed that the accused is beating the deceased. And then she proceeded.
She has not said that LW3 did not come.
My lord, she has said it.
PW3.
My lord, she has said it.
In the chief, she has actually said that he came, but in the cross, my lord, there is one suggestion, but in the last line of the cross-examination, she again says that he came. It's wrong. My lord may see that because it's suggestions.
My lords may have page 12.
It is not true to suggest that the deceased did not go along with Narendra on the date of incident.
My lords may have the middle of this very cross. It is true that LW6 Narendra never came to my house. Which version is to be believed, my lords? She has given 3 different versions. That's why I wanted to read from the High Court's record. On the first instance, my lord, I also believed it is typographical error. There are multiple versions given by PW1. And then, my lord, the PW7, the doctor does not relate
it. The date in the postmortem report?
The date, my lord, he has said that there is a mistake, but in the postmortem, my lord, it's written as 14/5/2000.
Everywhere.
Everywhere it's written as.
Everywhere.
We can't run away from that, my lord, but please may have one.
And this, according to him, postmortem commenced at 2:30, ended at 4:30.
Yes, my lord. At 2:45 and ended at around, yes, my lord. So
it is not that in the night, maybe 11, 12, there is some confusion about the date and he mentioned the wrong date.
My lord, the suggestion or the entire line of cross-examination in the trial was that, my lord, these injuries could have actually happened due to a fall. My lord, please see the reasons of, my lord, the injuries described by the doctor and the reason given, my lord, of death. There is no injury on the bottom side of the body, my lord. In the lower half, there is no injury. And the theory that they were propounding in the trial, my lords, the accused was there, it's a fall. Well, how can that be? And my lord, mother has been consistent on one bit, that she was called by Narendra, she went outside, she was also injured during the altercation, caste aspersions were also given against her. A convenience compilation is.
Yes, PW.
Of the original record.
We are seeing the postmortem only. Everywhere it is 14.5.
No, my lord, in the first top it is 13.5, my lord, actually.
And that is a requisition slip.
That's the requisition slip.
No, that is,
Just clarify.
it is not the postmortem.
No, the requisition slip is of 13.5, my lords.
Yes.
Then after that, my lord, correctly, but my lord has observed, it is 14.5 everywhere.
And my lord, that makes the date of death as 13.5.
No signature of the doctor at page 61, which is by the police.
It is by the police, my lords.
Yes. And he says that 12.5 he died, then 13.5 it is handed over for postmortem.
It's conducted on 14th, my lord. My submission is, and he finds that it is date of death, time of death is 12 to 24 hours prior to my examination, which makes it 13th. The entire prosecution story fails on that one.
My lord, the date of death has been recorded by the STPO, my lord, who is the IO, right, who was read out by my learned friend, my lord, is recorded as 12. That is consistent, my lord. The date of postmortem examination, my lord, is of 14. That is being given by them. He sends the body on 13th, my lord, signifying that the date of death is 12. And then from 13th, my lord, the date of the timing of death can be 12 to 24 hours. So on 14th, my lord, it appears, my lord, and I am stating as officer of the court, it appears that it's a mistake which has been done bona fide, my lord. Because you received the body on 13th, wherein the date of death is actually as per record on 12th, FIR is of 12th, and 13th, my lord, please see the injuries, my lord, recorded. How can those injuries be in the fall?
It is not at one place.
4 places.
4 places.
My lord, I understand that is somebody who is making the report. My lord, I quite appreciate what it's falling from my lord. He has consistently written 14.5, my lord.
To 24 hours.
12 to 24 hours, my lord. Even then, it is not corroborating. My lords may have page 75 of this very volume, only for the sake of completion. My lords may have page 75, exhibit P15, injury report of PW1. While we are dealing with indifferent timelines, my lord, this is very important. Page 75, exhibit P15. This is Andhra Pradesh Vaidya Vidhan Parishad Wound Certificate. First of all, there is no examination. So on by itself, it cannot be an evidence. But moreover, there is no mention of any timing.
But date is there, my lord, 12.
Date may be there. Date may be there, my lord. There is no timing on it.
How many hospitals?
And the doctor is not examined. Lordships have held the postmortem report by itself is not incriminating. You have to examine the doctor.
The postmortem has.
So what value this exhibit P15 would have? And High Court strongly relies on it. They could have examined Dr. Pawan Kumar, who has signed this wound certificate. Civil assistant surgeon. He's not examined, my lord. Not at all. Because there are many infirmities in the prosecution story, contradictions, hostilities.
My submission is limited, my lord. PW1, my lord, the testimony of PW1 in my humble submission has not been shaken, my lord, because of it is all in form of suggestions. It is not, my lord, she had contradicted one bit, or which is in the chief examination, or she has given a different version in the chief examination, my lord. And every other record which my lord have seen, date of death is consistent on 12/5/2013, my lords. It is only the post-mortem, the injury, my lord, although the doctor has not been examined, my lord, friend is right, my lord, but the wound certificate is of 12/5/2013. She has been injured, my lord. The first version that she sets up, the FIR is actually under 324 and the SC/ST Act provision, my lord. The first version that she sets up is consistent with what my ultimate quotation of the matter is, my lord, that he was attacked, and my lord, there were cast aspersions given while during that particular attack, and then, my lord, from those injuries, from a stone, he has died, my lord, while being taken to another hospital. We see the nature of it. There are 8 injuries, my lord. And if somebody has to fall, because that is what the cross has been, my lord, that shows the intent, what the accused has actually in their mind, my lord. How can you have on your jaw, my lord, then on different sides of the body, there is contusion on your chest, my lord. The fall will be at one place. There will be one grave injury, my lord, at one place. It can't be that you have 8 different injuries in a different place in a fall. It is
not fall.
My lord, it
is not fall. There is no doubt about it. Either he is guilty or not guilty. But not because he has fallen.
Inconsistency, my lord, what of the doctor is being shown that yes, because injury could have happened in the fall, that there is a gap in the story. But PW1, in my humble submission, and the chief has not been shaken at all, my lord. She is consistent.
If we find you guilty, then any other argument about
my lord, I have
whether it can be converted to 3
my lord, precisely.
Part 2,
my lords, for the reason it is not proved beyond reasonable doubt. There is no intention proved. Motive is also not proved, my lord. If my friend is not responding on the panchayat issue, the motive is not proved at all. Why would I kill? If they are maintaining about the occurrence, they have to prove the motive also. Where are they proving motive? Nobody has supported it.
The Panchayat Dars, my lord, it's on record, my lord. The Panchayat Dars have turned hostile.
It's not a public document of which Panchayat is on record.
3 people, my lord, who are independent have turned hostile. But, my lord, the mother is consistent that yes, my son took away the sister, and that is the reason
total incarceration?
5 years, 11 months, my lord, as per our calculation.
My lord, 6 years according to me.
As on
today, my lord. As on today. And there is no premeditation, nothing.
5 years?
11 months as per our calculation. My learned friend is saying
6 years.
And 5 years, 11 months actual.
Actual. I'll go with the statement. I have no difficulty.
Part 2, it is difficult. 8 injuries.
But my lord, there is it is covered under explanation exception 4 months. There is no premeditation, there is no intention. At most, knowledge can be attributed
of the marriage with the girl.
My lord, that is not proved, my lord. That I have shown. Panchayat has not happened at all. Nobody has corroborated. There is no independent witness at all on all counts, my lord. If one would believe PW3 went hostile, why would those Panch would go hostile about Panchayat?
Who is that Panch?
My lords may have PW4, my lords, and PW5.
PW4 and 5, my lord.
Both are allegedly the Panch who conducted Panchayat.
In course of investigation, they were there, my lord, but
one of the witnesses says that there was a Panchayat.
No, my lord, apart from PW1 in chief, nobody says.
PW5 doesn't say.
Doesn't say. PW4 does not support. In the chief itself, they become hostile. I did not conduct any panchayat in this matter. That's why precisely, my lord, I am beseeching your lordship that there is no motive proof, my lord. There is no beyond reasonable doubt. The conviction is bad, my lord. My lord, if it's not acquitting, my lord, then I have nothing else.
No, we do not know. Once it goes in the pipeline, what comes out, we never know. So tentatively we discussed and we are of the view that it's a case of acquittal, it seems.
Please, my lord.
Everything hinges around PW1. If PW1 is believed, then convicted. If not believed, then...
But may I say, my lord, if PW1 is believed, the occurrence may only be proved, not the motive.
The motive is not required. If
there is no mention, there is no premeditation, there is no intention in her examination. It's not ocular, my lord, if I may say. She was not there at the incident. She was called upon.
If there is no ocular, it's a case of acquittal.
Yes, my lord. That's my precise answer. It's not ocular.
Whether to believe PW1 or not,
please, my lord.
Tentatively we are with you, but let us see.
Please, my lord.
You never know. Heard and counsel for the parties. Reserved for judgment. You want to submit any submission?
I wish to do, my lord, 2 pages.
You also?
We'll find a synopsis of 3 pages.
Counsel for the shall submit written submission. Not more than
3 pages.
3 pages.
3 pages. Learned friend is 2 pages. I am not as
3 pages. Yes.
Obliged.
Yes.
That I am for respondent statement that I am seeking 4 weeks further time to file counter.
4 weeks for counter. 33.
Hello.
Adjourn. Yes, Panchayat versus Panchayat.
Lord, I appear on behalf of the respondent municipal corporation.
I request for a short accommodation in this matter. The counsel for the petitioner is not available. I request just for a short accommodation if my lords may kindly consider.
2018 matter.
I understand this.
It is that land, whether it belongs to the Panchayat or the municipal body.
Not belonging. Village Panchayat claims that the particular land is not part of municipal corporation. It is part of village panchayat. When Milord,
same thing.
Yes, it may not belong to. It may belong to anybody. Jurisdiction, whether it falls within the.
So it has to belong to either you or the corporation.
So belonging or maybe individual owners. Whether jurisdiction corporation runs or will not
belongs.
Panchayat. Yes, your
in generic sense.
In that sense.
Generic sense.
Yes.
So that who will collect the rent or the...
No, that's not the point. The real issue is there are unauthorized constructions. We wanted to demolish that. The individual owners of those properties have set up village panchayat obstructing all this. Everything has come on record. The status quo was passed. Collector's report was called for about your lordship. Despite status quo,
they say that municipal cannot demolish because it falls within Nagar Panchayat.
Yes. Yes. And Lord, 3 times reports were called for even your lordships, and Lord, the notifications were produced of 1945 showing that it is part of
municipal corporation since 1945.
And because of the dependency of this, the demolition is stayed.
No, but we can't because but if construction goes on, that's the report of the collector before your lordships.
Yes. Not petition is filed.
So why panchayat is here? Not they are not
precisely because they are village panchayat is small group of 8 elected people. Villagers will not do a organized construction. Set up panchayat.
Recording this. I appear for the petitioner. Mr. Sundaram was not appearing in this matter. 4 or 5 occasions he has appeared.
Entire township must have come.
No, but this is municipal corporation is huge area. This is a small part of that.
How many houses are there here?
That permission was granted by the petitioner village panchayat. Well, at the first time in 2013, they issued a notification. They are saying this is our area. And we have now found 1945 gazette.
You are appearing for
the Gram Panchayat. There is a petitioner. Both SLPs, I am the articles on record. My colleague was seeking a short accommodation because any date, tomorrow also, or some any time, accommodate me for only one. I am not fully prepared. I can explain everything. So far as those people who have violated the status quo order, I am not holding a brief from you. Your lordship may pass any order for me. And this is village panchayat because we have all these people have taken permission from me. All these years, 2013, first time, they have not taken any steps. For all these people paying taxes to the Gram Panchayat. Constructions, lordships have directed the collector to give a report regarding this. It was submitted that this violated the status quo order. The lordship may pass appropriate order. So far as that will are violating the order passed by your lordships. Only those constructions will are there. The Gram Panchayat has not collected taxes from them. Therefore, Gram Panchayat has filed a suit for a declaration that this 2013 notification, first time they have asserted their right. Now, 1945, we have that gazette notification.
January.
There, it's only the urban area, not the agricultural land.
He is not arguing, he is only impressing us.
Any date, I convenient to lodge. Any date, I'll not seek any adjournment or next date. Any date.
We'll hear next Wednesday, 18th.
18th. Please, Lord.
As with Bala Council for the petitioner, post on 18th February.
Grateful to you.
Bless. Oh, bless.
Yes, this is a matrimonial issue. The trial court had granted decree of divorce. The trial court had granted the decree of divorce, and the High Court has reversed it on ground that at one stage, the husband had filed a Section 9 petition for restoration land that was withdrawn.
Mike, please use mic.
The High Court has noticed that the husband had filed an application under Section 99 for conjugal restoration of conjugal rights, and that application was withdrawn. So the High Court takes the view that amounts to condoning the acts of cruelty. That's the matter before the Lordship, which have to be heard on merits.
Yes.
I have one respectful suggestion. Out of the wedlock, they have a daughter who is now over 23 years. And she's finished her studies possibly and almost in a manageable age. But we have, although she's working in a school drawing about 28,000 rupees per month, but that was suppressed. It was not brought on record before this. But we have now got a certificate from the school that has been produced. But we still will not honor the order of the Honorable High Court because your Lordship directed that the interim payment which has been directed to be paid. So we have paid in 16 lakhs plus 3 lakhs and 19 lakhs have already been paid. It is on her account. What I was suggesting, talking to my elder friend, that for the daughter something has to be arranged. They have never lived, they have lived hardly for 1 year together. After the child was born, she took away their daughter and they have never lived together since then. So the marriage is broken down. Look, arrangement would be for the daughter's marriage. So that should solve the problem.
The daughter is also a party in this?
No, she is not. She is not. She is not a party. So I was suggesting that I have offered some, whatever is my clients were willing to pay at the moment, not really, he's a farmer, does some kind of orchard, etc. And income is an agricultural income. So what I suggested is that if the parties could be sent to a mediation by a senior mediator. It failed because they didn't actually meet there properly. That's the report I get. Senior first. Where is the report?
Now there is no divorce. Divorce was granted by the family court.
Quite right. The
High Court has set aside that.
Yes.
You are the husband.
Yes. There is no doubt that the marriage is broken down completely. They have never lived together. Except for
the maintenance you are paying.
We paid already to her.
They had paid only until High Court.
No, but then after the orders of your lordship, they paid about 19 lakhs. 16 plus 3. You also see the order. The last order by my lord, the chief justice.
No, but that payment is also, that covers the pendency of SLP also, or?
It covers.
The maintenance was paid, lords, right up to the High Court lords time. Maintenance was paid in Supreme Court. But after the High Court judgment, not a single pie has been paid.
No.
You have to pay.
Quantify it by saying there is an order, can you see 11th of December 2023.
Up to 22 they have paid.
Then there is an order by this court and that amount has been paid.
That was the outstanding amount of the High Court judgment.
16 lakhs plus 3 lakhs.
This is arrears of maintenance.
16 lakhs was paid then and there. And then another 3 lakhs, that lordship will file an order 28th of March 20.
But you must furnish the calculation also. You furnish the calculation.
Yes. Up to 22nd September.
Not up to.
September 22 they have paid.
You give a breakup.
Breakup notes?
You give a breakup.
That we have given, 115.
Para?
Page 115, para 4 and 5.
115. There is no 115. We don't have 115.
Page 115, Lord.
Counter, yes.
Counter, page 2 of the counter.
So here the acknowledgement receipt of 16 lakhs and additional 3 lakhs has been paid as recorded your lordship order.
That was up to the High Court judgment.
No, you say it is 18 lakh 5,000.
Yes.
And he has paid?
They have paid, Lord.
That they have paid.
No, we have paid 16 plus 3, 19 lakhs in all.
19 lakhs.
But she has surprised that for all these years she was earning. This was on the basis that she had no earning. Her earning is 28,000 per month. But please see the certificate from the school.
No,
that was not there.
That has become final. Maintenance, what the High Court has.
No, High Court did not note. High Court proceeds on the footing.
High Court has fixed maintenance pendentality at some 15,000 something. That is on the page 28.
Yes.
15,000 per month plus 50,000. This is what High Court says.
Quite right, my lord, but this is on the premise that she has no income. She doesn't earn. That was on suppression of fact because she was already earning.
That has become final.
Only 15,000. That was not brought before the court. It has now been brought before your lordships. We got the certificate after RTI proceedings, which is filed, my lord, along with the rejoinder. What's the page? School says now she is employed from 2013, earning after deduction of PPF 28,054.
You pay the amount.
That has been paid. That amount has been paid out.
You have to pay this interim maintenance, 15,000, which is higher.
That has been paid, my lord. That is how it has come to.
Up to the High Court judgment, Lord.
You see, September.
After 22, they have not.
September 22. Up to September 22, it is 18 lakh 5,000.
But then you have to take into account that she is earning 28,000 per month from 13. That is suppressed.
Appeal is dismissed. On hearing and counsel for the appellant, we do not find any substance in the appeal. It is accordingly dismissed.
What is this? This does
We
not.
don't want to pay any maintenance.
No.
High Court has paid 15,000. Orally, you are saying it is too much. It is. High Court has already found you, and that is not under challenge.
No, that's not a challenge.
We don't want to hear. You are not willing to pay maintenance to the wife. We don't want to hear you. It's so simple.
I don't understand why you are saying.
No, we understand.
We have paid already.
You don't understand. We understand.
No, but the payment has been.
Why should you say we don't understand?
No, because I didn't.
We understand what is happening. You are not willing to pay interim maintenance to the wife during pendency of the SLP. The matter ends. It is that simple.
Your lordship may consider, my lord, if the parties could be relegated to.
That we are willing to subject you pay maintenance. You see, it is 3 years. September 22.
Lord, without prejudice, will pay. Without prejudice. If it is proved that she is earning and that is suppressed, your lordship will take appropriate.
What is the evidence that she is earning before us in this SLP?
The rejoinder affidavit, please give the page. There is a certificate by the school. I think there is a separate volume with the rejoinder.
Yes.
In that, if your lordship return. Page 6, Gita Adarsh Vidyalaya.
Yes.
Look, this has come on RTI. Please see what it says. She was appointed at PRT on 6th of February 2013 in our institution, that is so and so. And then turn over to the next page, my lord. Salary certificate. Basic salary 22, DA will have come 29,000. The only deduction is to not PPF, Provident Fund, and then 28,000 per month. This is receiving for all these years. We would pay whatever your lordships direct us.
The next page is your income.
That is his. I'm sorry, which one?
This income tax return is of yours.
Yeah, that is it. It's for the family.
22 lakh is the net agricultural income.
That is how we have assessed agriculture. That is true.
Even with this amount, she has.
Or whatever process is direct, but this has to be adjusted against our payment, which has not been disclosed.
No, even if she is earning 22,000, comparing your earning with her earning, she needs to be given some other amount.
You are also take a call on decide that. Well, I have nothing, no problem. But I was saying, you know, that the matter could be settled once and for all. They have never lived together, except for.
Yes, Mister.
Or even the marriage expenses for the daughter, Lords. Now she's of age.
What she does. The submission is that subject to whatever is the outcome and without prejudice to the rights,
yes,
they will pay something. They may also pay some expenses for your daughter's marriage.
Yes, of course.
Yes. But in the meanwhile, since the marriage has irretrievably broken down, consider mediation and find out a way so that both of you lead your own life peacefully.
It is sent to some senior mediator.
Senior mediator, that's what I suggested.
The parties are referred for mediation to be conducted by a senior mediator. Let the parties appear before the mediator appointed by the Supreme Court Mediation Center on what date?
Whatever date you lost it there, they'll go on that day. After about 2 weeks?
2 weeks?
After 2 weeks.
On 23rd February.
Not supposed.
The first appearance shall be by through virtual mode, and thereafter the parties shall appear either virtually or physically as directed by the mediator.
Not supposed.
In the meanwhile, petitioner shall pay a sum of rupees. Learned counsel for the respondent submits that the High Court had fixed the maintenance pendentility at rupees 15,000 per month, which has been paid to the respondent, and the areas thereof has been paid to the respondent. But since after the judgment of the High Court, no amount has been paid. Considering the submission, we direct the petitioner to pay an amount of rupees 2 lakhs.
Whatever losses are.
Because it is on nearly 3 years.
3 years.
22nd.
More than 3 years.
More than 3 years. At least 1 year. 2 lakhs will be good.
That's it.
Rupees 2 lakhs to the petitioner. Within to the respondent within a period of how much time?
2 weeks or 3 weeks, whatever losses.
Within a period of 3 weeks from today. Yes.
That's it.
When shall we post this? How much time it may take? 2 months.
2 months.
2-3 sittings at least.
That should be enough.
Post the matter on 11th May.
Yeah, that's it.
For submission of mediator's report. Yes, sir.
Item 26.
Yes. Yes.
Lord.
I appear for the respondents 1 and 2.
Yes.
I look for respondent. I appear for respondent 7 and 8. I am in support of the petition. 7 and 8. Respondent 7 and 8.
You are supporting the petitioner. Why?
The performer parties may not.
Pro forma party.
Why for the petition?
The respondent initially moved the land grabbing court.
It is civil revision.
Civil revision, Lord.
711. 711 or what?
711.
711 dismissed or allowed?
Dismissed. Against which I have come up.
You are defendant.
I am defendant. suit plainly barred by limitation. Will you kindly come to page 18?
Suit is for?
Suit is for recovery of possession.
12 years.
Yes. Suit is for recovery of possession, injunction, damages, etc. Will you kindly come to page 18? Page 18 is the proceedings initiated before the land grabbing court. That is LGC number 63 of 2000 at page 18. Land grabbing case number 63 of 2000, which was dismissed at page 79.
This was in 2007.
Yes, my lord. That was in 2000 and it was dismissed in 2002.
No, dismissed in
2002.
On 23rd August 2007 High Court order.
Yes, my lord, land grabbing court verdict is at page 79, conclusion.
No, but High Court order will give it finality. The parties have gone for writ petition.
Correct.
Writ court says that go to civil suit.
Kindly come to page 79.
Section 14 will apply even otherwise. Bona fide litigating before the writ court.
Lord, it was dismissed by the land grabbing court. It was dismissed by the High Court. Dismissed in special leave petition by this court. And 18 years after, because proceedings initiated in 2000, 18 years after.
When was the civil suit filed thereafter?
Civil suit was filed in 2018, June 2018 at page 90.
What June?
June, my lord. Kindly see the cause of action portion at page 98.
What is the date of filing of the suit?
June 2000, that's what.
10 years, 6 months, my lord. I'll give the date.
June 2018. Kindly come to page 98. That is the cause of action portion of the plaint. Cause of action. The cause of action for the suit arose in the month of June 2000. There exactly is my point. When defendant number 1 claiming documents from defendant number 2 to 5 relating to different properties started excavation work by encroaching into the suit schedule property and on noticing the same, the plaintiff filed LGC number 63 of 2000 for recovery of possession and 22/4/2002 when LGC number was dismissed, and on 23/8/2007 when writ petitions filed by the plaintiff and another before the Honorable High Court of Andhra Pradesh was allowed in part by common order dated with observations on 13/12/2007 when SLP number was dismissed by this Honorable Court, and the cause of action for recovery of possession is continuing as such. The plaintiff is entitled to file the above suit within 2 years from the date of last proceedings. Well, it arose in the month of June 2000 and the
June 2000, first time it arose, therefore thereafter land grabbing court, thereafter High Court, thereafter Supreme Court.
Yes. Correct. But when did the cause of action arise? In 2000.
Continuing, they say, and. If you read it, cause of action first time arose in June 2000.
Suppose you sleep.
To the suit on noticing same the plaintiff filed so and so. When LGC was dismissed, when WP was dismissed, and another before High Court was allowed in common with observation so and so. When SLP was dismissed, when means every time when this proceeding was decided, the cause of action arose.
My humble submission is this way. Suppose you wait for 100 years. Say when he refused to make it.
If you see, you may be correct when land grabbing court had no jurisdiction at all.
Yes.
But if land grabbing court had jurisdiction,
yes,
and the matter was contested by both the parties, and on merits land grabbing court dismissed their case, and then High Court says that file a civil suit, it is continuing cause of action, recurring cause of action.
Under Article 65,
pending.
Under Article 65, the period of limitation is 12 years.
Yes.
12 years from 2000 ends in 2012. Let us see how this was dealt with. The trial court says it's a mixed question of law and fact. Kindly see, page 138. Did not apply its mind at all. At page 138.
No, you want a decision on this during trial or in SLP?
What trial court said, it's a mixed question of law and fact.
No, it is.
High court said
not a mixed question of law and fact. According to us, it is within limitation. The suit is within limitation.
High court says.
Page 98.
Yes.
Read with Article 14.
Yes.
It is within limitation.
Page 138, 137 is the order of the trial court, which says that this is a mixed question of law and fact.
We'll keep it open.
High court says that you raise it as an issue, limitation will be framed as an issue. That is not an answer to Order 7, Rule 11. In every case, limitation will be framed as an issue. This is
your interest is protected.
No, at page 2. Kindly come to page 1.
Where is the SLP order?
SLP order, my lord, is page 89.
Observations are made. What are the observations?
No merit.
No merit.
No.
Lord, High Court now says, my lord, kindly come to page 1.
So who came in SLP? The Remax?
He came.
Huh?
They are.
No, you are Remax Construction.
No. I am
Proprietor of the company.
Mohammed Nurul Haq.
Remax Construction and others.
He's the proprietor. So
Sayyid Mukhtar Ali and others.
I appear for 190. And the third respondent?
Lord, in page 1. Kindly came to page 2, my lord. Para 7. The defendants having filed their written statement and the objection of limitation having already been raised. It goes without saying that the court below is required to frame the issue of limitation as the first issue while framing the issues. Therefore, while deciding the suit itself on merits, the court below shall ensure that issue of limitation shall be considered.
Because the petitioner in the SLP is Remax Construction and others petitioner.
Yes.
And Remax is the first dependent. First dependent in the suit, page 90.
He is the sole proprietor.
Sole proprietor. Anyway, yes. Yes, Mr. Chidambas. Take small order or big order?
The question of
choice is yours.
Maybe left open to be decided in the suit.
And also, my lord, the suit, my lord, within a reasonable time.
After the proceedings before the land grabbing court, High Court, and the SLP get concluded against the plaintiff, it was against you, against the plaintiff, a suit was preferred in June 2018. 2018.
Yes.
18, with the help of, with the assistance of liberty given to the petitioner, to the plaintiff, to seek appropriate remedies from a civil court. Full stop. Referring to the paragraph of the plaint containing, this is para 19 bracket Roman 5 of the plaint relating to cause of action, it is argued that the cause of action arose for the first time in June 2000 Therefore, the suit is clearly barred by limitation. Para. After hearing learning counsel for the parties, we are not inclined to interfere with the order passed by the High Court, mainly for the reason that the High Court has kept it open that while deciding the suit itself on merits, the trial court shall ensure that the issue of limitation shall be considered before considering the other issues that would be framed before the court below. Full stop. In other words, comma, according to the High Court, comma, the issue of limitation shall be tried as preliminary issue. Full stop. Para.
As required under Order 14, Rule 2.
No, it is. Preliminary issue is only one order.
Yes.
There is no other order which deals with preliminary issue. Full stop. In view of the above, the SLP is dismissed, keeping intact the observation made by the High Court. Yes.
A reasonable time for the
For?
suit, my lord, to be.
Since 2000 it is continuing, let it continue for some more time. You wasted your time. Yes.
Oh, bless.
In fact, Mr. Chidambaram has instructions not to make any prayer for early disposal of this preliminary issue also. Yes.
Very well. Oh, bless.
Yes.
Well, so the item 37, I seek a short accommodation to file the counter affidavit minutes.
May I please? Short means?
2 weeks.
2 weeks. 2 weeks for counter.
Obliged.
Yes.
My lord, I'm appearing for the respondent number 2, my lord. I'm appearing for respondent number 2.
My lord, I'm appearing for petitioners.
Petitioner. Yes. What you have to say?
My lord, we are here against the High Court order. We have a motor vehicle claim against the respondent.
Owner or driver?
We are the deceased.
No, deceased cannot be here. Claimant.
Yes.
Yeah, yes. They are the claimants, your lordship. They are the claimants.
Claimants. Why are you not paying?
We have paid your lordship. I'm appearing for the
This is for enhancement.
Yes, your lordship.
Insurance.
How much you have got?
Sir, my lord, we have claim initially of 60 lakhs.
60 lakhs.
Yes. My lord.
And the tribunal awarded?
Tribunal has awarded 16 lakhs.
26 lakhs.
16 lakhs 75 and 10,000 notional income was calculated. In High Court, it has been enhanced to 20 lakhs 75,000.
20 or 26? 20 lakh.
20 lakhs.
Now you want more?
My lords, seeing the scenario, the girl was only 19 years old.
Deceased is a girl.
Yes. In 38, it's a girl. And
what was she doing? What studies she was carrying on?
My lord, she was doing some work. She was working as a supervisor data entry operator. And she has just graduated her 12th.
What is the proof of her earning?
Nothing, my lord. Nothing on record.
Nothing.
The High Court has already.
What is her qualification?
From 10,000 to 13,000.
Just graduated 12th. And she was working as a data entry operator.
She was graduate?
Yes, ma'am.
At the time of death, she was a graduate?
She was a graduate.
In which subject?
My lord, it's not.
My lord, that is also not on record, my lord.
So notional income High Court has taken?
Notional income. 10,000 has been enhanced to 13,000 and then the award has been
High Court has taken 10,000.
Sorry. Trial Court has taken 10,000.
MACT has taken 12,000. High Court has taken
30.
There are two claims.
Two claims. I am appearing for 38 in 38, my lords.
In 38, there was a girl. In 31, he was a male.
No, you are in appealing both the matters. So in one matter, 1675 is made 2075.
Yes, my lord.
And in this matter, 2675 is made 3188.
Yes, my lord.
The first one is the deceased is the girl.
Yes,
And second is Murthy.
Yes.
Deceased. What was he doing?
He was a mason, your lordship. I'm in 38.1, your lordship.
Deceased was a mason.
Yes, your lordship. And he was 42 years old, your lordship. And your lordship, they could not.
There is no dispute about the multiplier.
No.
Multiply is correctly applied. Deduction is also 1/4.
Yes, 50% in the 38. In item 38, 50%, she was a bachelor.
She was bachelor, therefore 50%.
Yes. But 40% future prospect has been awarded, my lord.
In both the
25% in the second one.
In the second one, it's 25.
no, second also 40%. Future prospect is 40%.
Lordship, 25% was added as future prospects in the second one, 38.1.
It is only 25%,
Yes.
not 40.
That is according to the law, your lordship.
No,
Law is as
25 by both MSCT and High Court.
yes, your lordship. Both. In 31, your lordship, he could not prove his income, your lordship.
But there also High Court has taken 14,000.
My lord, yes, he was a mason. As estimated, his income was around 800 to 1200 per month. Per day. He was a mason.
But is there any proof of your earning?
No, my lord.
Then High Court has rightly taken it for 14,000.
My lord, seeing the future perspective also, the mason has a wife and children and a mother. They were solely dependent on him.
No, if there are more members in the family, his income would not increase. His income would remain the same as a mason.
Yes, that's true, my lord. But because he was the sole earner, the impact on the family is greater.
My lord,
therefore, his income should be assessed more. Yes, tell us.
Sorry, my lord.
If there are more members in the family, court should take his notional income more than what is assessed. That is what you are submitting.
No, not in the.
If there are less number of family members, we can take notional income in a reduced manner.
No, not on that perspective, my lord. I want to say that as he was the sole owner, the whole family, whether it will be more or the less members, the family is dependent on him. So the future, seeing the future perspective and the compensation which has given, it should be more sustainable so that the family can have.
It is only for that 1/4 has been deducted. Like in first one, because he was unmarried, 50% has been deducted for personal expenditure. But in the other one, only 1/4 is deducted. Because there are more dependents.
My lord, there has been a delay of 971 days in the assembly. 971 days of delay also.
Oh. So delay we will consider only when we interfere on merits. What is your estimate?
My lords, we are estimating.
How much we should increase and why we should increase? You tell us what evidence has been ignored by the High Court and the MSCT, which has caused you the reduced compensation.
My lords, we are saying that the compensation should have been somewhat more because the family is dependent, and in the first case in 38, she was only a 19-year-old girl.
Yes. But she was not earning.
She was a data entry operator. She was earning 20,000.
Ma'am, you prepare in a better way and argue. You bring cases. Here for a unmarried girl who is a graduate, some more amount has been granted. Our orders are there. Sitting with this Carol, I have passed some orders. You find out.
So, my lords may give us some time.
Yes, we will put it after 2 weeks because there is some scope of enhancement in first item, 38. There is slight chance of some post after 2 weeks. You prepare a chart, comparative chart, as to what is given to you by the MACT and the High Court. And then on what particular head you expect more and on what basis. Whether any High Court judgments, Supreme Court judgment, you deserve some more compensation. Yes.
Obliged, Your Lordship. Obliged. Item 39.
Lord, may I seek 2 weeks accommodation? I'm not feeling well, bad with sore throat, etc.
As paid by on counsel for the petition, post after 4 weeks.
Obliged,
Yes.
Lord.
40 also letter, post after 4 weeks.
My lord, I appear for the petition, my lord. Though, my lord, the respondent number 1 has been served, nobody is appearing for the state, my lord. If my lords will direct, we will serve the state through.
Direct counsel for the petitioner is permitted to serve the standing counsel for the state opposition.
Grateful.
42. 4 weeks, post after 4 weeks, letter.
43.
4 weeks.
Yes.
Circulated letter. Oh, I'm sorry.
42.
I must have missed it. I'm for the petitioner.
No, there is a letter, 42.
My central agency must have missed it. It's all right.
This is yes, by the respondent. Letter is by the respondent. Yes. Yes.
43, please, my lord. I am appearing for the petitioner in this case.
Yes.
My lord, I had issued notice on this. My lord, in this case, the High Court had, my lord, the Learned Tribunal has, my lord, granted attendant charges based on the formula given by this Honorable Court in Kajal.
We will wait for some time.
We'll wait.
Respondent is served.
Yes, respondent is served.
But there is no appearance.
There's no appearance. Yes.
Respondent's service is complete on the respondents. Post after 4 weeks.
I am grateful. Much obliged.
Please, Lordship. Yes. I'm sorry.
Take your breath.
Your Lordship, in this matter.
Wait for 1 minute. Musa call kar.
Item 45.
45 letter.
2 weeks time to file counter evidence.
Yes. 2 weeks for counter.
My lord, my request kindly fix a date, my lord. In this case.
Did March 1st week. Yes. Yes.
This is after notice matter, Your Lordship.
Yes.
They have not yet entered appearance. Similar matter is also pending before this court, Your Lordship. It can be either taken up with that, because this relates to the compassionate appointment of the divorced daughter who was dependent upon her mother, Your Lordship.
What is that similar matter?
Your Lordship, this. In that case, Your Lordship, the married daughter was considered not to be eligible, but High Court had given the appointment, Your Lordship. I even placed the High Court's order also at the end, Your Lordship.
But this is also by the Jharkhand High Court.
This is also by the Jharkhand High Court. This is pending consideration before my lords. In that, my lords have directed them to give the appointment subject to the outcome of the petition.
No. That is a different case because There the High Court has
High Court had
granted
granted
the
them.
appointment.
In this, High Court has not granted. So what I'm saying is that it can be also taken up and the matter can be listed for final hearing, Your Lordship, because they were to be listed in 2024, and yet they have not yet been listed, Your Lordship.
There are several matters pending.
2 matters before.
What is the third one? Third one is the High Court order.
High Court order. Show similarity, Your Lordship.
Learned counsel for the petitioner submits that similar issue concerning entitlement of married daughter.
In this, Your Lordship, the divorced daughter.
Entitlement of the divorced daughter to seek compassionate appointment is pending consideration before this court in SLP civil number 3.
Civil appeal number. It has now become civil appeal number. The second page, Your Lordship, is a different order.
No, which is the civil appeal number?
The first one is it has now become civil appeal. The leave has been granted in that matter.
Civil appeal arising out of SLP civil number 3000 of 2019 and SLP diary number 46021 of 2024. As per tag with so and so.
Lordship, may I request that she can also be considered for giving compassionate appointment, Your Lordship. Subject to
you have lost now.
I know.
Whatever you will get it finally.
So, Your Lordship,
there is no consideration.
May I request my
by way of interim relief.
May I request my lords to have these matters at any time, Your Lordship, as per convenience, because
now it goes to the chief. We do not know who will hear.
Your Lordship, in this order, the diary number, Your Lordship, my lords have said that it should be listed for final hearing in November 2024, Your Lordship. So I am just praying that any direction can be.
It will be heard by whichever bench it is assigned.
Your Lordship may just
let it be assigned.
Your Lordship may just say that it may be listed for hearing before appropriate bench in March, April, Your Lordship, because she is in.
Let it be tagged and then.
I am grateful, Your Lordship.
Yes.
Pass over matters.
Yes.
Item 2.
Criminal. None for the petitioner post after 8 weeks.
Item 14.
Lord, this case is for construction of a section, which your Lordship will find at page 13, 1-3. Lord, this is the High Court's judgment in 227.
Mr. Cole?
Yes.
You purchased it in 1966.
That's right, ma'am.
And they are, whether they are tenants, subtenants, whatever capacity, or whether they have paid the compensation or not, whatever, you could not know. Although according to the High Court, the appellate court has gone on presumption only.
Yes.
And presumption of the payment of rent or compensation. And High Court says that it could not have been presumed. But it's a case worth consideration. Means,
May I with respect say only?
Yes.
This is the litigation where now we have fought for 35 years.
Yes. What is the remedy for him?
Sorry, bro.
It belongs to you now.
No. Remedy, I'll tell you.
It cannot be evicted.
No, I'll tell you now. It's a very important question. Remedy is to evict me under the Rent Act on the grounds provided in the Rent Act. Bona fide requirement, demolition, this, that, you can do that. But you can't, my lord, throw me out without saying that you have no right. That's the whole point. If I am a deemed license, you see the section as the lordship rightly said. Section says, if you are there prior to 1273, even without the consent of the landlord, on an illegal subletting, you shall be deemed to be a tenant of the landlord. If I am deemed to be a tenant, then my lord, the rights of a landlord against the tenant.
May I with respect only say one thing and I leave it at that?
Yes.
I am a protected.
To go under the Rent Act, you have to show that you are a licensee.
which requires two things, occupation and payment of rent.
We'll record that after
The
hearing.
trial court,
requires.
just a minute, the
Give
trial-
that right.
The trial court categorically says there are no rent receipts.
You are also
No rent receipts on the cutoff date. All cutoff date which is given to be covered by the Rent Act, it was by an amendment to 15A, gives a cutoff date. Every rent receipt that they have produced is post that amendment. And secondly, my lords, who are the people who are keeping some tenants? One person says, I am the husband of the maid. The other person says, I had an oral arrangement. So the court, rightly the impugned order comes to a conclusion.
We'll consider. We'll consider.
Lordship.
Hear you. Issue notice to the respondent. Mr. So and so, learned counsel, assisting Mr. Cole, learned senior counsel, would accept notice for both the respondents. Three. There are three respondents.
Well, the other respondents are pro forma party.
Respondent number 1. No, who are they?
Well, the other respondents are our LR, other brothers who could not join as petitioners. They're pro forma parties.
No, there is no pro forma.
We'll serve them.
Don't issue notice.
No, we'll serve them.
No, we have to serve.
They will come that without hearing.
No, we must serve. Because tomorrow somebody will stand up and serve. I will serve them thus.
Notice be issued to the second and third respondent. Para, dusty permitted. Para. In addition, dusty permitted.
Yes.
Para. Post the matter on March 18th.
Below the status quo being
In the meanwhile,
it is executed.
petitioner shall not be evicted from the subject premises.
Without leave of the court.
Without leave of the court till the next date of the
Because may I only make one summation?
Yes.
For 50 years, we have fought for this. For 50 years. All that I am saying is a party who with such tenuous basis for the case holds on to the property dishonestly should at least be put to some terms in the meantime.
I'm sorry. I have not.
You have held on. There
it is flat.
These this is in Bombay in a prime area on the ground floor.
These are 2-3 rooms. It's a dilapidated house.
2-3
flats.
in a lot.
It's a dilapidated
Your entire
house.
ground
10 years
floor.
old.
These subtenants.
What is the total area?
Total area of the ground floor?
No, we could assess the potential.
I have understood what you are
Yes, my lord. We have both understood.
We can work it out, Lord. Next time if there's anything, there's no issue.
Yes, 17th March.
We can work it out in March.
18th March.
Fine. I'll also find out. Make a proposal to you.
No, they are paying only 15 rupees, 20
No, Manoj, we are getting nothing.
You are getting nothing.
We are getting nothing because they.
Don't worry, we'll give you something.
No, we don't. We want our property. As simple as that.
You said put on terms.
No, terms meaning not to pay me. Term in the meantime to illegally occupy the property.
I'm sorry.
You have an action against you, not to pay me.
It is also. In the meanwhile, petitioner will not be.
This. Yes.
And at the same time, the petitioner shall not create any third party.
Yes. No problem.
In the subject premises.
Lordship.
Grateful.
After notice matter.
Yes.
Records in terms of your lordship's last order, my lord, records has already been brought. Today, my lord, this matter may take some time, my lord. For the reason that the whole appeal has to be heard, my lord. But this man is in custody for more than 14 years.
What is the matter?
But it is 302 matter, my lord.
302.
302, my lord. Your lordship has issued notice.
How many eyewitness?
3 eyewitness.
3 eyewitness, my lord. All related. All two are brothers, my lord, and one is the friend. No, and my lord,
You see, nowadays relatives are the best witness.
No, not what I'm saying.
Because independent witnesses are not supporting.
No, and
कौन दूसरों के झगड़े में पड़ेगा?
Yes, timing.
They are always turning hostile.
And timing, my lord, what is important is timing of the incident is around 8 p.m. in a main bazaar. Now, my lord, in main bazaar there are hundreds.
Today we can't hear this.
Today, your lordship, but my lord, your lordship.
Counter is filed.
My lord, counter has been filed. My lord.
If there are 3 witnesses, why have you issued notice?
No, my lord.
Why have we? You are in jail since
14 years, my lord.
Maybe because of that.
14, more than 14 years, my lord.
11 year, my lord, actually.
Your lordship will do one thing, my lord. In order to give a quietus also, my lord, I may make a request, my lord. For period undergone, my lord,
not two, there is no undergone concept.
Now, my lord,
undergone only after 20 years.
But 14 years, my lord, he has already.
There is no undergone concept in 302.
Very well. Then your lordship may,
the minimum is life.
Your lordship may grant leave in this matter. Your lordship may grant leave in this.
You have been released on bail.
No. Your lordship may release on bail.
No, we'll hear it.
Then, Lord, it can be heard only.
Depositions are on record.
On the
All miscellaneous case.
All the deposition.
My lord. But in original record is also, my lord.
Record has come.
Yes, sir.
Record has come.
The record of the trial court is available. Post the matter on 7th April.
7th April.
Tuesday.
Very well.
Hopefully we'll decide it.
Very well.
Not uploaded.
Yes.
Uploaded. Deadline.
21 region, sir. My lord, I am advocate. You are board, judges are board assistant on the earth.
What?
May I speak in Hindi?
Yes, yes.
हाँ, आप थोड़े वो नमस्ते आपको चरण वंदना और मथा इसलिए टेका जा रहा है